Item number 1.
All the next.
Item number 2.
Yes, I am for the petition. You are the only respondent. But this matter, when the applicant was working to the post of senior chief goods clerk, chief goods clerk, CGC, chief goods clerk in the railway department, he was charge sheeted major penalty. And at that point of time, the charge sheet was issued by the incompetent authority, that is DCM, Divisional Commercial Manager. Now, my lord, that charge sheet, the tribunal has setting aside and the said charge sheet. And ultimately, my lord, against the said charge sheet, a major penalty punishment of removal from service has been awarded. When the applicant made an appeal against such penalty order, the appellate authority found there is a mistake in respect of that. Thereafter, my lord, that punishment order has been reduced to reversion in a lower gate. Chief goods clerk to goods clerk. I have challenged the said order before the landed tribunal. In a first round of litigation, the tribunal has set aside this order, and tribunal set aside the order of the appellate authority as well as the disciplinary authority. And at the same time, tribunal has given liberty to act in accordance with the law. The railway respondent did not restore my service to the post of chief goods clerk. And my lord, what they have done, they have issued again a charge sheet. Already in the earlier charge sheet, the applicant has suffered for a punishment of reversal. And till now he is suffering. One of the second round of litigation, when we have challenged the order of this authority regarding the charge sheet, but if your lordship sees straightway in the charge sheet, it is absolutely not maintainable. Kindly come to page 60, my lord. Come to page 57 in the charge sheet and kindly come to page 60. The article of charge is very important, Mother 60. But just I am reading, Mother. That's the Gunjan Kumar petitioner hearing, CCC, ISG under CC1, JSG, Southeastern Railway, while posted at PIRP station, has committed serious misconduct that he has given unauthorized absent from his duty at BIRP from, but date is very important, 26/5/2015 to 10/5/2015. How can it be? Kindly see the period, my lord. They did not rectify this charge sheet by way of making any kind of corrigendum. So where is the unauthorized absent, mother? I had challenged the charge sheet before the landed tribunal. The landed tribunal recorded the earlier findings and earlier order, and tribunal did not fail that the petitioner was not restored in the service, despite the earlier bench has set aside the order of charge sheet, appellate authority order, and disciplinary authority order. Now the applicant is still now suffering the said punishment, despite the setting aside by the earlier bench of this tribunal. When Marat I had challenged this charge sheet before the landed tribunal, kindly see the impugnment who is on that challenge, page 64. The tribunal did not take care into the article frame in the charge sheet. Paragraph 4. At hearing, the landed counsel for the applicant submits that after receipt of the fresh charge sheet, memorandum dated 15/6/2023, the applicant denied the charges leveled against him by way of a representation. However, the disciplinary authority did not accept the said representation and decided to conduct the departmental inquiry against the applicant. Accordingly, the applicant was called by the officer, inquiry officer, for a preliminary hearing, which is he attended. Subsequently, during pendency of the department and inquiry, the applicant submitted his representation on 13/5/2024 and requested that since he is already suffering the punishment.
Where is the speaking order of 13/6 to 20?
Yes, kindly see the page number.
Fifty-six, my lord.
56, Annexure A/6 dated 13/6/2023.
All right, just let us go through it.
Yes.
What is your grievance?
My grievance is, my lord, they themselves has admitted that charge sheet is a faulty because of the incompetent authority as per this order.
There's no question of admission. The tribunal has already declared.
Declare.
Yes, there's no
Now,
question of
in the second time when they have issued a charge sheet, my lord, can you see the article of charges? They did not rectify the mistake, whatever may be.
What mistake?
They have framed a charge restriction article of charge 26/5/2015 to 10/5/2015.
My lord, date is
Please. Yes?
But kindly see page 57,
Yes.
the memorandum of charge sheet, the article of charge sheet.
No, what is it? Tell us first, then we'll see. Tell us what is the grievance, then show where it is.
My grievance is, my lord, when I was working to the post of chief goods clerk, I have gone for mother treatment. For my mother-in-law, I gone to the treatment. I have taken the leave from the authority, and authority, my
Not
lord,
chief goods clerk, chief commercial clerk.
CGC,
chief commercial.
chief commercial clerk.
Yes.
My lord, at that point of time, I was gone to the outstation for my mother treatment.
We are not on merits. What is the infirmity in the charge memo that we are asking?
Infirmity in the charge, already I suffered a punishment in respect of the earlier charge sheet.
Yes.
They have reduced the lower rank to the post of goods clerk by way of a penalty.
Yes.
And my lord, that penalty that I was already suffered,
Yes.
and that has been set aside by this tribunal. And tribunal,
Correct, because it was by an incompetent authority.
yes.
Yes.
Now, in a second time, my lord, they have issued the state charge because I already suffered a punishment, my lord.
That has already been set
And I
aside.
am
Don't
suffering.
say that. That has already been
And they
set
did
aside.
not reinstate me after the order of this tribunal.
That is not correct. They have designated you in the charge memo as chief commercial clerk.
But
Your earlier post.
I was not
Not on the reverted post. You see, come to page 57. The present railway board undersigned
maybe
hold
yes.
an inquiry against Mr. So-and-so CCC.
TCC, can you see their order?
That is the post that you were originally holding.
And
You
that
were
is the-
reverted to goods clerk. So there is no question of not giving effect to.
And kindly see, madam, page number 448.
48.
Yes, this is the order of the appellate authority. Earlier, 4.
Why should we look at that?
Yes,
They have already rectified. They have issued a speaking order, page 56.
yes.
After that, if they have issued a fresh memorandum in terms of the liberty granted by the tribunal.
Yes, yes.
In the fresh memo, they have addressed you as CCC.
Yes.
C is the post
All
you
right,
are
but
holding
I am
prior to your reversion.
This charge sheet is a defective one.
All right, now, so why? Then let us
Yes.
see why.
Kindly,
Yes.
kindly see how, একটু স্যার বলতে দিন আমাকে please.
Yes, please address us.
The prayer, ma'am.
Kindly see the article of charges.
Yes. What is the infirmity?
Page number 60, article 1.
No. Why are you reading the articles? That is for the inquiry to consider, not the High Court. The articles are, you
Alright,
will
there are-
reply and they will.
There are catena of precision
Yes,
in any stage of disciplinary proceedings,
yes.
court can interfere.
We are not on that aspect.
But if there is a technical ground, my lord can
So
also.
therefore, what is
Sir,
that
the
ground?
technical ground is very clear, page 60.
Yes,
Kindly see the period of absence.
yes.
26/5/2015 to 10/5/2015.
10/10/2015, not 10.
10/5, kindly see.
10/10, sir, not 10/5.
Sir, page 60, this is the.
Yes, we are reading page 60.
Yes.
26/5/15 to 10/5, 10/10/15, not 10/5/15.
See 10/5, my lord. Kindly see 10/5, article 1.
We are reading article 1.
Article 1, kindly see.
Here it is correct. That typographical error does not.
But they have to rectify.
See the next paragraph, that is
Yes.
is clear.
Yes.
It is 10/10/2015. That is
Which
nothing.
paragraph কোথায়?
That will
No.
not invalidate. Again,
No,
in
no, I am again, another point is, Madam, is
Yes.
it not a double jeopardy? A man cannot be punished twice.
how is it a double jeopardy?
First of all, I was punished
Yes,
by the earlier authority,
all right.
incompetent authority,
Yes.
by way of penalty of.
So your
Reversion.
point is double jeopardy, and what else?
First of all, I was punished by the incompetent authority by way of a reversion from chief commercial clerk to clerk, goods clerk. Now again, Marat, the appellate authority has reverted my post, and that has been set aside by this tribunal. They did not restore me as a, maybe they have stated in the CCC, but they did not restore me in service of CCC after the order passed by this tribunal. But at this stage, Marat, there is a charge sheet issued. Now, order of the tribunal is very clear to set aside all the punishment order. Why the applicant, why the respondent did not pass any order, I has to be allowed to the post of CCC. But if your lordship direct me, I can peruse the payslip.
No,
I am
not
wanting-
required. Not required.
No, they have to restore me first.
If you have annexed, then show. If you have annexed, then show. It must have been before the tribunal. If you have raised this issue, it must have been there before the tribunal. So we are seeing the tribunal's order. There is
Yeah,
nothing
Lordship
of
can-
this.
yes, we have pleaded. Paragraph 4, Lordship can see.
Let's see the OA.
Paragraph 4, Lordship can see of the judgment.
No, OA. Show us from the OA.
Yes. এটা কোথায়? কত নম্বর পাতা আছে ওইটা? কত থেকে আরম্ভ? Lordship, can you see, we have taken the point of the original application also. তারপরে যে প্রিজনারকে রিইনস্টেট করা হয় না।
That is not your case. That's not pleaded by you anywhere. Come to page.
Yes, I have stated, Lordship, I am
30. Come to page 34.
34. Yes.
Page para 4.16. From there onwards.
Senior Division Commercial Manager Chokkodapur had issued a speaking order in which he had cancelled the faulty charge sheet. Cancelled the faulty charge sheet. But he has not restored me in service.
So we are looking for that line. Where is that?
Yes, yes, I am giving this paragraph.
Yes. That's not your case.
Yes, page 34, Lordship, can you see 4.18. As the applicant has been punished on the same charges as per charge memorandum dated 21/8/2017, and as he is still suffering the punishment.
Still, how suffering? That is what we have. to
Lord, I am
plead.
submitting with oath, my lord, if your lordship telling me I can file an affidavit.
Then file it. File it,
Just
then you
file an
make your,
affidavit.
in absence of pleading, don't make submission.
I
You
shall
file
file
it.
supplementary
For
affidavit
filing
and
a
I know what-
supplementary affidavit,
My lord.
we grant next.
My lord, much obliged.
আমার রেজিস্টারটা করে দিই।
Item number 3.
But what will be the next date? Next date? It will appear after 1 week.
1 week, yes.
ঠিক আছে।
Item number 4.
কত তারিখ কত? Supplementary affidavit.
We are appearing on behalf of the applicant respondent.
Yes,
Oh, sorry.
not today.
Item number 5.
We are appearing on behalf of the applicant respondent.
This says we cancel it. Then they issue the fresh certificate. At time they do this. But that is not clear from this pleading. Adjournment was not restored. I think it was not restored. He should have filed a contempt before the
This is my affidavit.
This is
This is item number 5,
your affidavit.
affidavit service.
You are appearing.
I'm appearing on behalf of the applicant's respondent.
All respondents are present. All respondents are present.
May I
Then
tell you lots of very short facts. In 2006, an original application was filed by the two applicants. Then what I did in 2000, claiming certain career advancement benefit scheme.
Arrears.
Then what I-
Under which heading? Arrears under arrears of salary.
fixation of pay,
Oh, fixation of pay and arrears arising out of such
career
fixation.
advancement scheme, cash,
All right.
which is called cash. Then Malat 2011, the applicant number died. No steps was taken for substitutions as provided under the Civil Procedure Code or under the Administrative Tribunal Act. After 11 years or 8 years, 9 months, an application for substitution was filed. The state has taken the point that application is no expulsion. Then Malat they subsequently withdraw the application. Then Malat they have filed an application for setting aside amendment. That application was not placed. But then what about final hearing, when the learned tribunal have objected that about the mentality of the operations. We don't know. So far as the ban concerned number, there is no amendment to the constitution. Then the date persons cannot, order cannot be passed by the tribunal. But since that person's not on record, his legal heir should be given all the benefits.
Since his daughter,
Legal heirs,
what legal heirs were there on record?
not record. File the application. Kindly see for a moment. Application for substitution at page page 82 for condemnation or delay of 8 years, 2 months. Prayer, page 82. MA number 242 and 243.
When they are and why you have not produced the letter at C?
What?
Why part of a document is annexed? When you are annexing a document, is the whole to be annexed, or it can be annexed as in part only?
No, entire document.
Then why it is not there?
Which one?
You have annexed the substitution application.
Yes.
Come to paragraph 2, 3, 4. All these paragraphs, they contain reference to letters which have been marked as A, B, C. Where is this A, B, C?
Oh.
This amounts to suppression of relevant and material fact.
Yes, yes, yes. But, which was supplied to us, that is to be nothing but.
This is no answer. If this is your answer, we can deal with it. With open eyes, if you see an application that there is an annexure and you don't bring it to the knowledge of the court, where have you said that only this was supplied? We are unable to annex because it was not there. Don't say it, sir.
But can you see the order passed?
No. Why should we? We want to see the why you should annex only part of it.
No, order.
This amounts to suppression of a relevant and material fact. They are relying upon a letter at C in paragraph 4.
That chapter is closed by page 85.
By 85,
Yes,
whatever
page
it is, why should we not see? This is the background. This is the relevant and material fact.
But we are relying on page 85. That's nothing more.
Whatever it is,
But because application has been withdrawn,
so therefore you will annex only part of the document.
oh, certainly.
This is not the way. Please try to ensure that in future this does not happen.
Yes.
These are relevant and
Your
material
logic is
facts.
perfectly correct. Your
Yes.
logic is perfectly.
Now what is 85? So they withdrew
85.
their.
That both the applications were withdrawn.
Yes. Both
Yeah.
applications means
Application for substitution and application for condonation of delay.
and for
Condonation of delay.
condonation of delay. Yes. So the other applicant continued.
Were
There were two
provided-
applicants.
Provided the verification has to be made because verification was made by a dead person. If I verify on
So
the
now the order that you are challenging is not an order passed in favor of this person whose matter has been withdrawn. It is in favor of the other person.
other persons who is doing, his legal hair should be permitted, who are not before the court. Can you see? But a page, internal page 3. Paragraph 4. Mr. Banerjee further submits the benefits of this order may extended to the members of the disease applicant GN Bhatak without substitution or setting aside amendment. How the learned tribunal has got jurisdiction.
Where is that? Where are you reading?
Madam, kindly see internal page 3 of the impugn order dated 8th December 2022. Last order, impugn order.
So you are only aggrieved by insofar as the person who is already deceased.
Wanna kindly see the application who has been affirmed at page 44.
No,
Before the tribunal.
therefore, we are asking you, there are two aspects of the matter.
Yes.
One is that one person is deceased, applicant one is no more.
More.
His legal heirs have withdrawn.
Ah.
The substitution and his legal heirs have withdrawn the condonation application.
Application.
You are aggrieved by the fact that relief has been granted in his favor or otherwise also.
Or otherwise also. because-
Otherwise, because the applicant one has shown the verification and he is no longer there, so how the tribunal has
Yes.
proceeded?
Order 22.
So which provision supports your submission regarding the applicant number 2?
The first one, kindly see the who has affirmed the affidavit.
No, that we take it, you have said we without seeing, we take it for your submission that the applicant number 1 has affirmed it.
Affirmed it. Then,
Then
as soon as he authorized by the person to verify the affidavit, as soon as he
I
did,
have understood, but you must be relying on some legal proposition, some provision to say this.
yes, kindly see the impute order for
Yes.
a moment. Kindly see next paragraph. After hearing both RADA advocates, considering the facts of the order 22 to बात करना order 22 to बात करो order 22 rule 4 rule 2
also same thing will apply therefore for the same.
Yes, so what are you relying upon? Let us see.
I'm relying upon order 22 rule rule 2. Although civil procedure code does not apply, but principles will apply. Rule 2. I will not see got it.
Just give us a minute.
And rule 3 also.
3 will not apply.
Mona?
3 will not apply.
No, the last line. And shall cause the legal representative of the dispensary to wait a party and shall proceed with the case. That means amendment has taken place of the original proceeding.
No, this is talking about legal representative of the deceased.
This is
Applicant number 2 is not a legal representative of applicant number 1.
no.
He is an independent applicant. He is not a legal representative.
He is not a legal representative.
Yes.
Then what are the, if two plaintiffs are there,
Yes.
one plaintiff died.
So therefore, 2 you may stretch 2, but how 3 will apply?
No, what are as soon as what are the original application filed by the two persons, one died, and verification made by the person who is on no more in the world. That means authentications or authorization goes, and as soon as the died, proceedings abated. In abated proceedings,
Abated proceeding for that person or for everyone?
entire proceedings abated.
So that we don't see from either of these provisions. That is not there.
Because what I kindly see, even assuming for a moment that so far as person who was alive, that proceeding was maintainable. Then in that event, what I kindly see for a moment, who has page 44 for a moment.
What is page 44?
Page 44, authentication and
That
verification.
we are accepting without seeing. We have told you already that the applicant number 1 has verified.
Yes,
He has authenticated. We take it without seeing.
Yeah.
And you say he has passed away, so everything goes.
yes,
For all the other petitioners also.
yes.
That we are finding it difficult to accept based on Order 22, Rule 3. It doesn't appear. Let us see the provision regarding verification in the act or rules. Must be there in the rules.
क्या rules चाहिए थे तो बिना rules ना हाँ नहीं इसमें ना रखे तो
Where is the procedure here regarding verification? You are referring to CPC, which in terms of the act itself is inapplicable.
not
The legislature has in so many terms said that it will not apply.
apply.
And the tribunal will be guided by principles of
Not
natural justice. Principles of natural
Natural
justice, not by the principles in CPC. You are relying on those provisions, but you are not showing the provision regarding verification.
Section 19 is of the Administrative Tribunal Act. Application has to be filed. Section 22 for a moment, but of the Administrative Tribunal, have you lordship got it?
This is not it. Sir, we are asking you to show us the provision regarding verification. Why can't you first show us what we are asking and then take us wherever you want to take us?
Just give me 1 second. Verification to কোথায় আছে দেখো তোর বইটা দে ওটা গোলাপি বইটা লাগবে স্টেট রুলসটা হুম গোলাপি বইটা
Mr. Mukherjee, you examine it, not today. We'll see on Monday. You have also understood What he is saying, we'll hear you on Monday.
Lordship would be kind enough to look into the order itself, Your Lordship.
We are asking you to clarify it out. You think we have not seen the order? He has already shown the order.
Item number 6.
Interesting question. This was serial number 5.
May I please, Your Lordship, I am back to appear for the petition.
I am for the respondent in this matter, Madam.
All respondents? Yes. All. Yes. Where is the file? File. Oh.
And the petition before Lordship is an employee of the Director General of Quality Assurance.
Director General of
Quality Assurance.
Quality Assurance. As
As well as JTO,
Junior Technical Officer.
Senior Technical. Now what happened, my lord, before 2008?
What was he as?
Junior Technical. Junior Technical Officer.
Junior Technical Officer. Yes. Which group?
Group B.
D.
B.
D.
Non-gay.
Yes.
Now, before 2018, there was no policy of transfer. Nobody was transferred from one place to another. In 2018, for the first time, a transfer policy came. That is at page 37. Don't know, continue. According
13,418.
yes,
Yes.
from that, after that policy came into being, well, the transfers were being made.
Prior to this, there was no transfer policy. And there no transfer was being effected.
I was in Mumbai initially, then came on transfer on own request.
It is not introduction of a transfer policy. It is introduction of certain category of transfer.
Yes.
It is not introduction of a
Rotational
transfer
transfer,
policy for the
rotational.
first time.
Rotational.
Yes. It is not that before this there was no transfer.
No, no.
Before this also there was transfer.
From here, nobody was transferred.
That is a different thing. That is a factual aspect. That does not mean that there was no transfer policy.
No, no.
You said there was no transfer policy. That is not the position. Yes.
Now, my lordship, kindly come. This policy says who are exempted
Yes.
from for disability of self plus dependent. Next, for husband and wife working at same station.
All right. So which one you are claiming benefit?
Both B and C.
B and C.
Yes.
You are a junior technical officer where?
In Kolkata.
Kolkata is the office name.
Director General of Quality Assurance. DGQA in short.
Yes.
Now,
You have been here since when?
2006. They did not transfer me anywhere.
Lord, may I point out one thing, my lord?
Please, yes.
Now, after this policy, my lord, I made representation.
Why? There was a transfer order issued.
Yes, yes.
Where is that? Show us.
At page 40. This is under, my lord, this rotational transfer policy of 2018,
You are at serial B.
serial B. And it says, my lord, the following posting transfer orders are under RTS 2018. Just I have shown, your lordship.
Yes.
Now I made image 45, my lord.
Your representation.
Yes. There are two grounds, my lord. Mainly, my widow mother is psychiatric patient who is dependent on me. Another is my husband is an employee of the Eastern Railway. Eastern Railway, Kanpur does not come within the jurisdiction of Eastern Railway. And I am also suffering from orthopedic problem of knees. Body,
Yes.
Now they rejected it, page 57. On the ground that the documents have furnished do not cover any kind of terminal illness. But the policy itself says disability of self-dependent medical ground, not saying that only terminal illness and husband and wife.
Then why did you say B and C? You are relying on D also.
Yes, yes, yes.
You said B and C.
Sorry, my lord. I beg to excuse. Then what, my lord, I challenge this. The tribunal earlier under litigation said that you consider and dispose of by a speaking order.
Then speaking order is passed.
Yes.
Where is that?
So you want to- Page 50.
Page.
Page, my lord. Page 99. Page 98, my. Page 99 is, paragraph 9 is other reasons.
Yes. Then
My lord, one of the grounds for rejection is that my mother is not dependent on me
yes.
as per service records.
Yes. Then you again move the tribunal.
Yes, yes. Now, if your lordship kindly comes to page 120.
120.
Yes. This is my declaration of family and dependence. They say my mother is not dependent as per service records. Now, the lordship knows that one has to give declaration of dependence and family. There is prescribed form. Now, lordship will find serial number 3, page 120. Onupa Bhattacharya, Judge.
Yes.
Mother. Already on record that my mother is my dependent. Even before my marriage also, my mother was my dependent. That was declaration was there. After marriage also, this declaration is there.
No, this declaration is of January 17.
Yes, once I have to give declaration. Before marriage, once I have given declaration that my mother is my dependent.
Where is that?
That is not here, my lord. I am having. I have to file a supplementary with that. That
Where have you said in the original application that prior to this also you had made a declaration?
no, that
Let
I
us
did
see
not.
from the
Because no, I did not. Because of the fact.
So
my
there
lord,
is this fact is not before the
no.
Then let us see what
But
happened
well,
thereafter.
latest declaration is there.
That is what we are saying, 2017. Yes.
Yes.
Now let us see.
Mother is my dependent. They say it is not on record.
No, they say it is not part of your service record.
This
Now
service
let us
record.
let
Yes,
us see
yes.
what happened thereafter.
That's why while admitting this case, my lord, the Honorable High Court asked them to bring the service record also.
Yes. Now let us see what happened.
This is the declaration everybody has to give.
Where is the order passed by the tribunal?
Yes. Such a kindly come to বলছি একটু পরে একটু দাঁড়া ভাই 217
12, 207.
17 17. If your lordship kindly comes to a page annex, in internal page minus If your lordship kindly comes, the learned tribunal upheld the speaking order, which is at page 222. না দিকে যাচ্ছি যাচ্ছি আস্তে আস্তে যাচ্ছি।
Yes.
Now, here also, the learned tribunal, we placed on record this document that I have already, my service record contains my declaration of dependent and family. That is must.
Where is that in the order? Let us see.
In 222, my lord, while upholding the learned tribunal upheld the speaking order, that ground also,
No, where is your, you have made submissions which have been recorded. We have not been able to see that you have said about inclusion of your mother as a dependent before the tribunal.
yes, I placed
Let
it
us,
on record, page 120, through supplementary affidavit. Sorry, and we return, no? That is not before the tribunal.
that was an annexure.
Yes, annexure.
But there is
This
no
one-
reference in the order of the tribunal to this.
Yes,
Neither you have made any submission in this.
yes,
regard.
I pointed out.
Let us see. Where have you said? That's what we are trying to see.
I annexed this document. My case is that was not considered by the learned tribunal. That's why we are before your lordship, my lord. The tribunal did not consider at all this document.
What is the date of this declaration?
2017,
17,
24/1/2017,
17 for 2000,
24/1/2017.
24 1.
And in the meantime, the situation further worsened because my husband is now suffering.
Where is the supplementary affidavit filed by you?
I have annexed, my lord.
It starts at which page?
Annex করা নয়। Lordship, kindly come to re-under page 105.
105.
Re-under. This is my re-under before the learned tribunal. And page 112, my lord. Relevant paragraph. Declaration form was annexed RJ2. Representation.
Yes.
And my lord, in the meantime, the situation has worsened because I have developed handicappedness. That was also annexed to supplementary evidence before the learned tribunal. That was discussed also. This was not considered at all by the learned tribunal. Page 67 is the disability certificate.
Page
67 is my disability certificate. And report.
Yes, all right.
And Illa, as it would have been, my lord, they rejected initially that no terminal illness should submit any document. Now my husband is suffering from cancer.
So the tribunal has said that they will consider
Yes, that part.
whether you have chosen to avail of that liberty or not, we don't know.
No, my lord, because stay is granted. Stay was granted by this honorable High Court. Stay was granted.
By this court.
Yes, by this coordinate bench.
Yes, that is all.
Madam, my mother is psychiatric patient. I have already stated here.
What you
And
have
there is
stated, you
nobody-
need not repeat. We have understood
I'm
everything.
very sorry.
My lord, the tribunal has, my lord, granted liberty.
Where is the record? Let us.
Your lordship, kindly come my PDP, my lord, at
Yes.
page 28. Her declaration. Sir, out of 25 years, 23 years she is in his.
Where is the declaration?
My lord, page 28. Kindly come.
Page
Her-
28 of.
Her declaration of the APDP in opposition, my lord, filed by my learned, my.
Don't give us that 23 or 25 year. We have read that you have said so many times. Don't say that. Where is the declaration?
Page 28, my lord.
Declaration. It is declaration. Yes, sir. Declaration.
Affirmed by one Vishal Ramesh Chaudhary.
Where is the declaration?
Page 28, your lordship got it, my lord.
20?
28, page 28, your lordship got it.
What is this?
This is the initial appointment record.
Well, her declaration, I will show to your lordship, my lord.
Oh.
This is All India Service, paragraph, my lord, D, if your lordship kindly see, who will liable to serve anywhere in India and who will be.
We are asking you whether she has made a specific averment in her rejoinder that she has given a declaration that her mother is dependent.
I am not disputing that.
So that is not in this.
I am not disputing.
All
I am
right.
disputing that the married daughter cannot make her, my lord, mother as dependent in the service book.
Yeah.
That is not permissible in law. He may declare anybody in her service record.
Where is that law?
And where is the bar?
My lord, bar, my lord, that is, my lord, today, my lord, I thought matter may not be taken up. That rule today I have not
No,
brought.
that is the only issue. Don't say that.
Very well.
Don't say that.
Now, my lord, apart from this, my lord, if you also kindly see her declaration at the time of appointment, my lord, this is All India Service. 23 years she is in the same position in Kolkata.
We have seen.
Now she, my lord, don't want to go anywhere. Apart from this, my lord, the tribunal has specifically directed the authority to consider, my lord, in light of the observation. My learned friend, my lord, wrote a letter to the authority. And on the other hand, he also, my lord, approached before this honorable court. Now, if your lordship kindly desire, my lord, we can also consider her, my lord, case. In
You
terms
have
of the,
applied for consideration.
yes,
No,
You have
we
not,
have
please make a specific.
No, we have no
statement.
instruction, my lord. I have,
they have
Yeah.
applied.
wait.
Apply করেছে. They have applied.
After order.
Yes. They have applied.
See, that will make a big difference. Therefore, we are asking.
I have to take instruction.
Otherwise, no, he is saying that they have the application. How do you say you don't know? You are there representing the applicant, you
No.
don't know.
They have not said
Very
anything in the reply.
There are many things. he-
Opposition.
We'll record his
Opposition.
submission. We'll record his submission. That the application has been made. Because we asked you also, you said there is a stay.
Yes, stay.
So that is not a answer to the query whether you have made an application.
Then
or-
lordship kindly keep it on Monday.
Yes, you come back, tell us on
Monday.
Monday. The learned counsel for the applicant submits that.
For 8 years.
So so the dad has said if that is the situation, if he's suffering a terminal illness, he will make a representation. He must have.
Item number 7.
For the respondent. Is not here. Your lordship. Oh.
Your Lordship, Mr. Bikashanand Bhattacharya, Senior Advocate, he's engaged in the matter, Your Lordship. He is not, if I'm praying just for not today, it has just appeared in the list, Your Lordship. If it could taken up on Monday, Tuesday, any day, Your
Not
Lordship.
today.
Item number 8.
Your Lordship, I appear for the appellants. This is a matter relating to army personals seeking second pension.
My lord, I am also appearing, my lord.
He's my senior in this matter. He's leading.
Your Lordship, I am for the respondent, my lord, the sole respondent in this matter.
My lord, may I request one thing?
Yes, who is for the petitioner?
I'm the petitioner, my lord.
Yes,
And kindly see page 29.
29.
Para number H. On the same issue, my lord, Honorable Apex Court granted stay. Interim order still, my lord, continuing, my lord.
Where is that order? Let us see.
I have annexed, my lord, page number 158. Page number 158 and page number 159. I have annexed, my lord. On 30th January 2024, my lord, page number 159.
No, what is the stay?
On the same issue was the same, my lord. Similar order was passed by the
Supreme Court has directed a stay of which order?
of my lord, Kochi bench, my lord.
Where is that?
Kindly see page number 158, my lord. Arising out of final judgment and order dated 26 July 2022, my lord.
Where is that order of 26 July?
That order was, my lord, not inadvertently not annexed, my lord.
Not
So-
inadvertently, my lord. That
Yes.
has not been, that has intentionally not been annexed because, my lord, the issue will reveal that that is a separate thing which is not in connection with that, my lord. That has been intentionally. My lord, I have the order, my lord. If my lord permits, if it's the matter on Tuesday, my lord, I shall produce the
All right.
court order.
As played by Learned Counsel for the Union of India.
Item number 9. Item number 10. Item number 11.
I am for the applicant. দেখো বলি Pinned order at last page of your lordships.
You are for the respondent.
Someone is,
Item number 12, my lord.
oh,
The respondent is not here.
I have informed just now.
He is
Can
here.
I wait for some time? I leave it to lordship, my lord. I cannot keep
It is your resolution today. Is he coming?
She has informed me she is coming. That is why I leave it to lordship.
Then you let us see if she comes, then we'll proceed. What is the issue?
issue
give
is
us-
recruitment process of 18. Petitioner being the candidate made an application having the requisite qualification
Recruitment to which post?
for the post of forest service
Forest Service.
under the
All India examination, IFS.
state government directly PSC recruit by that. Now they have been allowed to make their application, made the application, accepted, admit card issued, or written examination, petitioner having the successful candidate. When they were to go to the next stage of selection process, that is interview, the authority did not call them. Issue was there that I did not have the requisite qualification. After process,
You did not have?
that requisite qualification for making the application itself.
What is the advertisement?
But advertisement is first annexure, and I have annexed the recruitment rules also on the same syllabus. More interesting thing is this: the similarly situated person approached the tribunal, got the interim order, direction was there to participate in the interview, and result was published. Petitioner being the same on the same footing, having the same qualification, were denied. Kindly see this article 14. Advertisement at page 17.
Yes, qualification is at page 18.
18, and I shall take your lordship all the rules also. The
Bachelor's degree or
computer application here mentioned. Computer science, engineering, all are the
So you are for WBFS or WBSFS?
SFS. Page 21 kindly sees West Bengal Service and West Bengal Subordinate Forest Service Examination 80. And the authority from where I got that degree, they have the authority to declare that whether the same syllabus or not. They have issued that certificate also, that it is the information technology is parameter with the computer science.
And where is your degree
Yes,
that you have relied upon?
yes. I have mentioned in the application form itself, page 24 also.
No, where is it?
But mentioned BTech 2008, such and such.
Page?
Page 24. In the application form I mentioned. They have accepted. And immediately thereafter, I made a representation pen 26. Mentioning that you have allowed me to participate in the written test. Now in the midst of the selection process, whether this can be denied. Oh.
So graduation, you have written BTech.
Yes. And information technology is the same syllabus, page 31 at the university statement. Now rule also there. Page 141. The authority from where, my lord, I have got the degree, they have ascertained they are the same syllabus. They are the appropriate authority to declare this. Not the PSC or court can ascertain this. Page 141 kindly says. That is a vital document. They have not denied this. They have, as their own, declared that. In the opposition of that before the tribunal itself. Kindly see 141 itself. They are the best judge when in terms of the Honorable Supreme Court decision. Your Lordship knows this, and our High Court also held the if any degree or syllabus is not the same, it is the best. Expert is the authority from whom I have got the degree itself. And even after the admission, the tribunal went up 4 years to waste time. I say so, without allowing us or passing any interim order also. At that point of time, kindly sees the rule itself also says 166. This is the rule upon which that advertisement made. 167 is the qualification mentioned. 168 bottom. 169 computer engineering. Thereafter computer science also there.
No, where is for SFS, subordinate forest service?
This by this notification they have made an advertisement. This is the rules of this has been made under article 309. Kindly come 166.
This is the one applicable to the subordinate forest service.
That is also applicable.
And same is applicable to both.
No, and by this government notification, they have made the advertisement. If I
so qualification is at page 167.
Yes, 167. Thereafter another
at 42.
Yes, 169 also kindly sees. Computer science, computer application, computer engineering, all is the same. Computer, and that too relates to information technology. We cannot deviate from same set of syllabus. And in the kindly come to 173. There is one corrigendum also. There also page 174 that qualification mentioned.
Page 174.
Yes. 173 is the corrigendum. And qualification also equivalent of science or engineering or from the recognized.
What is 174 is a different notification.
It's a corrigendum, it is, I believe.
Huh?
This is the corrigendum.
Oh, corrigendum has been modified.
Modified. West Bengal Forest Service Recruitment Rules 2014, that rule also mentioned here. These rules may be called, it is written. So, advertisement coming from this. Now, kindly come to page. I'm coming from page. Give me 1 minute time. Application before the tribunal itself at page 142. Sorry. 142. Now 142. Yes. 142. This is, I have made an application after making representation refused by the authority for redressal of my grievance for participating in the selection process. Now kindly come to page 145. I have made the elaborate discussion to there.
There is any order passed by the authorities?
No. Inaction on the part of the authority not to allow me to the
Then
participate
you approach the tribunal.
And this application made 145 paragraph B and C. And even after the allowing me to participate in the written test without raising any objection that I have not any requisite qualification at that point of time making an application, they could have rejected my claim itself.
What is 145? D.
145 paragraph B. My Lord, God is subject to correction. Statement of my clients.
That representation has not been considered.
Yes, I could not have been allowed because of that. This is the paragraph B and C. And my Lord, kindly come to most interesting thing, paragraph page 151. In respect of another set of applicants having the same degree, information technology, the tribunal on very that date of the interview concern allowed the applicant, directing the authority to allow the applicants of that application in the interview board. And that application, interim order, was finally merged with the final order, resulting the publication of the panel. Whether the fate of the selection process, they have got the appointment, that is not. But we could have been allowed to participate in the selection process. My pair was there. And our case, series of interim order passed, but without giving any effect. Ultimately held, since the selection process.
No, from this order,
My Lord.
show where it says that the applicant therein, he was having a BTech degree.
Yes, unless no BTech, they could not have been allowed in the written test.
No, this document
Document
P5
does
that,
not, I checked it up. That document does not speak
that it has,
at, even then allowed. But
No, no.
fact remains,
you are relying upon this order passed in favor of the applicant at page 151.
yes,
You are claiming parity with him.
yes,
Now you have a BTech degree.
I have BTech.
So from this order of the
In-
tribunal, please show where it says that he has a
Correction, my
BTech.
Lord, that person not BTech, information technology. And the plea was taken also.
No, where does it say he had a BTech degree?
Well, no qualification had been mentioned also. But I know this.
How?
I know this. I know this. Because of the fact we are the same boat. But also there is no mentioning they have been allowed.
This order of the tribunal was before the tribunal,
Yes, placed.
where it has been considered.
And my Lord, kindly come to our all interim order. Thereafter, after our my Lord, pair before the tribunal itself, panel at that point of did not publish. They could have published the panel. I could have come, but after my Lord, approaching the court tribunal, the panel published in the month of December 2020.
Oh, now process is over.
I know this. I know this. That is why my Lord, at the initial stage, I could have submitted before this bench that after the expiry of the panel, nothing remains. Now that has been held ultimately. Now, my Lord, Honorable Division Bench, to that effect, if I approach the court within the validity of the panel, then my Lord, my right accrues. And when this is a settled law of the Honorable Supreme Court, my Lord, in the year 1999, your Lordship knows that the judgment of Purushottam. And that judgment has been relied on, at least, my Lord, I have checked it up 300 times. Your Lordship also. If the legitimate claim of a candidate having requisite qualification does not, my Lord, allow them to participate in the selection process, and I have approached the court within the time of expiry of the panel.
When did you approach the court?
Yes, 2020, kindly see.
When
First
did you
order.
approach the tribunal?
Yes, first order kindly sees at page, which is the page 1. Page number দেওয়া নেই তো impugn order বলে ও আচ্ছা But kindly come after 186.
One
After page 186, because this is the original order of the tribunal, I cannot touch it by making pagination. I have annexed from there. I also had the
is 186.
180 after 186. The certified copy. Kindly see first approach, 22nd of June 2020. And panel was published even prior to the date of publication of the panel. I have approached. Panel was published when I am giving the date 1/12, I believe so. Just now I have shown. Yes. At
What was the date of personality test?
Personality test, they have not given any date to me, but it is the date, I believe so. It has been mentioned in that order of earlier co-litigant at page 151. On very that date, personality test was there. That is date of 14th of February.
14th February
2020.
Oh,
We did not get any chance to appear because of the fact we were not notified to appear. Immediately thereafter, the representation made. When representation made, I am giving this.
No, but personality test was in February 20. You have approached the tribunal in June 20.
June,
then how
because
it can be?
we would not aware of this fact because of the authority withheld our application.
Where have you said in your application? In
Oh.
DOA, where have you said why you are approaching in June? Let us see.
Yes.
Yeah,
And I'm giving that. ওইটা বার করতে হবে, ওই যে আমাদের রিপ্রেজেন্টেশনটা যেটা করেছি ইমিডিয়েটলি ওইটা আছে। I'm giving the date itself. ওই যে ডেট আমরা জানালাম ইমিডিয়েটলি। ডেটটা কোথায় এটা? ও, পেজ 26 March, when I came to know, and the authority themselves withheld our application without saying yes or no.
This is your
I mentioned also.
This is your application.
Yes, answering. I mentioned also. My date was on 22nd January 2020. On my interview, it was not allowed to appear in the interview because I had the information technology.
No, then you must have been issued an interview letter. Where is that?
It
letter?
must have been issued.
Where is that? Where have you said?
Yes. I had the information technology degree, which is the same as comprehensive. I was assumed by the commission, assumed. It is.
No, let us see from your way what you have
Oh,
said.
wait. Yes. Way is at kota page? Way is at page. I'm coming. Yes, I have stated in paragraph B 151 bole na eta.
What? Can you give the page, please?
Yes, I'm giving this page. My lord, kindly excuse me 1 minute time. A lot of pages are there. আমাদের ওইটা কোন পেজে রে? ও আচ্ছা দাঁড়া দেখে নিচ্ছি। My lord, kindly come to 145. Lot of pages are there, my lord. That is why, my lord, it's very difficult. It is mentioned. Middle portion from paragraph B. Elaborate discussion, appear. West Bengal with a prayer to allow him to appear in the said personality test, and the representation are still unheeded. That is why I approached before the tribunal to make a fresh interview, and prayer was there. And you see the prayer itself also. Comprehensive representation as well as the adjournment as well as the prayer of the in the tribunal itself. Prayer at page 148. And C also I have categorically stated that this is the same syllabus. that from the comparison with the syllabus and the course structure of BTech and B, tribunal initially could have allowed us, since we have made the prima facie case after successfully done by the commission in a written test itself. Prima facie. Because we have made out a positive clear case after successful in the written test itself. Well, I believe so. An initial honorable division bench question, that question itself, that is why I have prepared that the judgment of Justice Purushottam itself. Kindly
Let us see. Which paragraph you are relying?
My
Just read the relevant part.
paragraph. 4 paragraph judgment, much value. Sorry. No, 8 paragraph. May I read for you, let's see. There also successful candidate was not allowed to appointment. In view of the rival submission, the question arises for consideration whether duly selected person for being appointed and illegally kept out of employment on account of untenable decision on the part of the employer can be denied the said appointment on the ground that in the panel was expired in meantime. We find sufficient force of the contention of Mr. Deshpande appearing for the appellant in as much as there was no dispute that the appellant was duly selected and was entitled to be appointed for the post, but illegal decision for scanning committee, which decision of the committee has been reversed by the High Court and the decision of the High Court has reached to the finality. The right of the appellant to be appointed against the post to which he has been selected cannot be taken away on the pretext that the panel in the meantime has expired and the post has already been. Oh, sorry, sir. Sorry. 1999, volume 6 SCC. And in slew of this, Honorable Division Bench of our High Court, presided over my Justice Dipankar Datta, held what will be the next course of remedy if the in the meantime panel has been expired of earlier selection process. That also discussed following the Supreme Court decision 2000 volume 3 SCC 699. Suppose I am the impanel candidate, I have the right to
have that judgment.
Yes, I have. And I have got this. I had the occasion to appear there. That is why. And here also primary teacher recruitment process ratio decided that the person is entitled to be appointed.
So tribunal has passed order in your favor, Mr. Mukherjee. What the tribunal has said.
Last page. Only that panel has been expired, nothing to be done.
No.
Dekho na.
Mr. Bhattacharya submits the prayer for constituted an interview board for the post of West Bengal subordinate forest exemption 2018. But the new commission, now the commission has already completed the entire process of recruitment, including responding the name of the circuit court candidates to the respondent authority. We are the appointing authority. We are not the selecting authority. PSC is the selecting authority already.
That's all.
I want to kindly see the judgment cited. The crucial word selected person. Selected
Paragraph 2, third line.
third line.
Yes.
But kindly see the paragraph 4, or sorry,
Paragraph 2, third line of Purushottam case.
Yeah.
See paragraph 2, third line. Undisputedly.
was selected for the post of assistant.
Correct. So that is what you are trying to.
He has not been selected.
That we have understood what you are.
Unless I give
Little
them
understanding of
premier to be selected, how that can become?
No, why little understanding? You are enlightening us. Where is you have much more than little.
I am a learner.
And we are reserving it. CAV 50.
Much. Yeah, much obliged.
Item number 12.
I am appealing for the response. I brought the records, my lord.
My lord, I am for the petitioner, my lord.
I brought the records. Yes, I am.
My lord, on last occasion, my lord, liberty was granted to me to file a supplementary affidavit, my lord. May I be permitted to file the same?
Can you see the order 11, page 113 passed by the Honorable Tribunal? The matter relates to compassionate appointment.
My lord, this matter do have a checkered supplementary. My lord, liberty was granted to me on earlier occasion. I have served a copy, my lord. Supplement also. My lord, this is only pertains to the reply and rejoinder before the tribunal.
I brought the records, my lord. Kindly see.
So all of it is material which was before the tribunal.
Before his lordship, my lord. My lord, if I am allowed to place this case, my lord, this has a checkered history. It takes us to the year 2001 and 2. My lord, the present petitioner, the father of the present petitioner, was an employee under GSI.
Under?
GSI, Geological Survey of India. My lord, at that point in time, when he was in service, he was declared medically incapacitated. That is during his service tenure. At that point in time, the applicant and the prevalent rule was that if someone wants to apply for a compassionate appointment in case of medically incapacitated, in that event, the age bracket has to be within 55 years. Now, the application made by the late father of the petitioner was prior to 55 years, but by the time the department, the respondent authority decides whether he will be declared as compassionate appointment or not, he crossed the age bar of 55 years. The application for compassionate appointment was rejected. Being
when? What is the date?
In the year 2002, my lord. My lord.
So within a year.
Within a year. Thereafter, immediately thereafter, the late father of the petitioner, along with the petitioner, moved before the Central Administrative Tribunal. The petition got rejected. Challenging that, an appeal was carried out to this honorable court, which was penultimately decided in the year 2016. That will be reflected from page 28 of the writ petition, my lord. The order starts at page 25 and the relevant portion is at page 28, my lord. If I am allowed to place the last paragraph of page 28. The respondents will consider the case of the petition number 2 for employment on compassionate grounds in accordance with law and if necessary be relaxing the age limit of the petition number 2. The petition number 2 is the present petitioner in this writ petition because in the meantime, in the interim, the petition number 1 has already expired. That was the father of the petitioner. The consideration shall be made within 8 weeks from today.
Right. So relaxation was to be granted to you.
Some relaxation, if applicable, then it has to be granted.
Then?
Now, my lord, at that point in time, no representation, the candidature of the petitioner was not considered at that relevant point in time. After this order was passed in 2016, the candidature of the petitioner was not considered by the department within the relevant point in time. If the petitioner moved this honorable court by filing a contempt application. The contempt application was subsequently dismissed also on the ground that be as it may on the belated stage.
Order has been passed.
The order has been passed.
Where is that order?
My lord, the order of the contempt. My lord,
no, where is the order passed by the authorities?
My lord, I'll come to that order. This is at page 49. This is of 5th of June 2018. During this point in time, the contempt was pending. My lord, the 5th line from the bottom, the CAC, that the Compassionate Appointment Committee, followed scrupulously the procedure in compliance of the standard guidelines for grant of compassionate appointment in the office in terms of circular number such and such dated 4th of June 2015
laid down in the compendium of GSI regarding compassionate appointment in this department and also followed DOPT norms from time to time amended related to the matter. So thereafter, on the very next page, second paragraph, the candidature of Sri Rana Mukherjee was considered along with 34 candidates. There is no provision for considering candidate for giving appointment on compassionate ground by taking into consideration the person with disabilities, Act 1955. Only in case of direct recruitment, Chapter 6, the Persons with Disabilities Act 1955 provides for employment, including identification of posts which can be reserved for person with disabilities, and extent of reservation shall be not less than 3%. Accordingly, CAC recommended name of one candidate who was awarded maximum relative merit point for consideration of compassionate appointment in this office, wherein name of such and such, the present petitioner, was considered along with other candidates but was not recommended for consideration for offering appointment of compassionate ground, as he got relatively less merit points. My lord, there,
Where is the scheme under which
My lord,
the initial application was made? The scheme under which the initial application was made
my lord, the app,
on account of the father being incapacitated.
my lord, that scheme does not reflect in that application.
Hmm?
The scheme does not reflect in the application made by the late father of the petitioner. But the scheme which they're relying upon is of 2015. There lies my case, my lord. I have twofold grievances.
So therefore, where is the 2015 scheme?
My lord,
Page 51A in their annexes, 51 starts, but illegible, my lord.
and
51.
there's a type copy also
Yes.
accompanied by type copy.
Type.
My lord, 51A is the scheme.
Get this. Ask someone to get this. Get some. Get a new one. This is finished. Yes.
My lord, 51A. This is
And
the
what is the date on which you had made the application?
2002, my lord.
So this will not apply in
This will not
2002.
apply. That is one-fold grievance. Assume,
Not one-fold grievance. Where is the
my lord, the scheme which will apply for form part in my supplementary affidavit, it starts at page 28, my lord.
Supplementary.
Annexure P19.
It was not before the tribunal.
It was not before the tribunal.
Just now you said you are bringing material which was before the tribunal.
My lord,
Now you are saying it was not before the tribunal. Very
My lord,
peculiar
there is a-
submissions.
there is an averment to that
We
effect.
asked you at the very beginning, are you bringing documents which were forming part of the record? You said yes. That was an incorrect statement.
My lord, that was only in respect
Now
to
when
my-
you have filed a supplementary bringing on record documents which are here for the first time, are they not entitled to make a reply?
My lord, they are. My lord.
Then why? We asked you at the very outset. This is wastage of
I
time
tender
unnecessary.
my apology, my lord. This document was not there, but the pleadings was there, my lord, in the
We
application.
asked you whether you are incorporating documents which were before the tribunal. You said yes. That was incorrect. Don't try to justify that incorrect statement that you have made. We asked you at the very outset. We didn't want to waste time. Therefore, we asked you. If you have brought new material, they at least they're required to give an opportunity to see. You are starting to argue as if there is nothing new, and then you are placing new documents. You have seen it.
I brought the records, my lord. Kindly see the record, my learned friends, client, my lord.
Have you seen this scheme that they are referring?
They have not, my lord, the annexed the documents before the learned tribunal.
So you
Yes, and also this is the lacuna in the part of the main recap. Passing this Honorable High Court's order, my lord, on last occasion, on 17th September 2024, my lord is directed to my learned friend to file a supplementary. On this court, my learned friend has filed a supplementary scheme of the compassionate appointment. I have already brought and discussed by the learned tribunal. Judgment starts from page 113. Kindly see the judgment passed by the Honorable Tribunal. Elaborately discussed. 113. Start relevant parts. It starts from 140. Order.
Now it is not under the old scheme. Now it is to be considered for compassionate
I
appointment.
hand over the records of.
And that compassionate appointment, now the scheme is 2015 scheme.
Hello.
Where is that 2015?
2000 starts at 51A.
Page 51A, 2015. That's from page 51. Updated standard and rules and regulation for the post of compassionate appointment in GS. Geological survey.
There is a quota against which the compassionate appointment can be made, 5%.
5%.
Where is that?
I handed over the records, madam. Kindly see the records, madam.
Is it there in this scheme, in this circular? Is it there in this circular that we are just seeing? It
My
is
lord, that
5% that
Page
I recollect.
53, my lord.
Page-
Quota of vacancies and number of grant of compassionate appointment. The applicant shall be considered by the CAC only against vacancy meant for the compassionate appointment. The quota,
Page 53.
page 53,
50.
3.1, the first paragraph, my lord.
First paragraph. The applicant.
3.1.
3.1. My lord, at,
3.1.
my lord, at the very bottom end portion, presently it is 5% of the direct recruitment vacancy.
3.1 you have not enclosed.
My lord, page 53, my lord.
53 top, my lord.
3.1. Yes.
My lord, the second last line in that paragraph,
Quota percentage of vacancies.
presently it is 5% of the direct recruitment vacancies of Group C post.
5.
Airways.
So therefore, what is your grievance?
My lord, my grievance is regarding the way, the mode and manner in which this calculation have been made, my lord. What has happened immediately when I filed this contempt application before this honorable court, I went on making several RTI queries with the authorities. And I have also received the replies about the candidature of the person who have been considered for the appointment. And there lies, my lord, blatant anomalies as to how this
How many people were appointed?
my lord, during that period up till 2018, altogether 4 persons.
Out of 34, 4 have been appointed.
4 have been appointed.
So you are disputing the calculation of 30 people.
Right.
31 people.
My lord, I am disputing only my calculation with the person who have been appointed.
No, because 31 people must have unduly
There might
gone
be a
above
possibility.
you, then only. Otherwise,
There might be a possibility. My lord, what I have done, if your lordship be kind enough to come to page 45 of my supplementary affidavit, there is a comparative analysis of the numbers secured by
how do you know the numbers which have been
my lord,
secured
from
by,
the RTI, my lord.
by the other candidates?
From the RTI queries which I have raised and the replies which I have received all throughout from the department, from the
They
respondent.
have furnished the detail of the other candidates.
They have furnished the details of the other candidate as to the marks secured by them.
Yes.
Because there are, my lord, altogether 11 parameters under
Correct.
which
So the marks have been given with reference to all the parameters.
all the parameters.
Where is that?
My lord, kindly, if you, I'll tell you with the page number, kindly take page 45 of my supplementary affidavit for once.
This was also not before the tribunal.
This was before the tribunal, but
Page-
this was handed over at that point in time, my lord.
Reply and rejoin.
Page 45.
Page 45, my lord. My lord, on the very first column, this is the category under the scheme itself. It starts with status of GS, that is a government servant. And if your lordship be kind enough to turn to page 55 of the scheme in the writ petition, your lordship will find the relative merit points to be awarded by the CSA according to the state.
These are the, there are names of only 3 persons.
3 persons, my lord. 2 have been appointed, the third column from the left, Sushila Devi and Renu Singh. These persons have been appointed in the year 2016 and 17 after the order was pronounced by this honorable court. And this is the person appointed in the year 2018.
So whose calculation you are disputing?
My lord, all 3, my lord. With the one with my client, that is the petitioner, Rana Mukherjee, the very second column.
First,
The first column, Rana Mukherjee is the petitioner, my lord. My lord, kindly, if your lordship be pleased to kind to relationship with ex-government servant. Your lordship will find the exact thing in page 55, 8.2. Relationship of applicant to the government servant. Lord, there are altogether 7 different categories under which the marks has to be awarded to the person who have been appointed. Lord, kindly take unemployed spouse or physically handicapped son, daughter, widowed.
That is not the relevant criteria.
My lord, I'm only on the marks, my lord.
Yes.
Page 55, 8.2, the very first one, unemployed spouse or physically handicapped son, daughter, widowed.
Yes.
The awarded marks ought to have been 10.
Yes.
The petitioner before your lordship is a physically handicapped person. Now, my lord, kindly tally the same with page 45. I have been awarded only 8. Whereas the person who have been appointed in the year 2016, 17 and 18 have been awarded 10, 10 and 7 each.
10,
Now,
10 and 8. Oh, 10, 10 and 7. Yes.
10, 10 and 7.
Yes.
I have been out. I have been.
Why are you speaking in between repeatedly?
I have been awarded 7. The last appointed person was also appointed 7. In the intergram, this 16 and 17, they have been awarded 10. Now, my lord, kindly come to page 80 of my writ petition for once.
Oh, so what is wrong with this relationship with XGS?
My lord, I have been ought to have been awarded 10. I have been awarded 7 because what they used to do, they used to put the marks, they used to accumulate the figures, and thereafter a total number of marks will be awarded to the person.
Correct. On all the parameters, they will be
And all the
assessed.
parameters.
Merit list will be prepared, and then subject to availability of 5% vacancy, they will be appointed from the in terms in order of merit. That we have understood.
I bowed on this.
Now, then what is
My lord,
wrong? We are asking you.
My lord, they are only rejecting my candidature
Yes.
on the point that I have secured less merit points than
Correct.
the other person.
Correct.
Now, if there is aberrations lies in the
So
calculation,
what is the aberration? That is what we are asking you.
my lord, I have been awarded 7.
Yes.
Despite being a physically handicapped person, whereas those persons are not being physically handicapped, they have been awarded 10.
They
So,
need not be physically handicapped. If they are a spouse also, they will be given 10 marks.
my lord, in that event, I am securing 3 marks less than them.
But even a spouse is entitled to 10 marks. It is not that only physically handicapped will be given. So
My lord,
don't say that.
My lord, I am saying,
Yes.
assuming their spouse, they are
Must
entitled
be.
for 10.
They have been given 10 marks because of being a spouse.
Being a spouse, but
Yes.
I ought to have been also awarded
So
10.
show about yourself.
My lord,
You had applied as a handicapped. Where is the application? Where is the certification of handicap?
that also,
How do you say it has been overlooked? Let us see.
my lord, that has already been formed part of the order passed by this honorable court in the earlier round of litigation, because the Persons with Disabilities Act has to be considered because there is a specific direction by this honorable court.
So therefore, did you apply as a physically handicapped? Did you give any certificate? Where is that?
My lord, I have given, my lord. I have given.
Why are you not showing? We are asking you a simple question.
My lord, if your lordship kindly bear with me, let me first finish with this. The anomalies which lies in this thing, I'll come up.
No, satisfies you are. This is one of the criteria. Satisfies with this criteria, then you move to the other. You are saying they should not have been granted 10. We appreciate your submission that unless they are a spouse or handicapped, they will not be granted. Even if they are not handicapped, they can be granted if they are a spouse. Then you say, no, I was also entitled to 10. So show us. Now don't jump to the other criteria.
My lord, my application does not reflect whether I have submitted or that or not.
So that,
But
now let us come to the next criteria.
But my lord-
Which is the next criteria?
lord, but my lord, in this case, my lord, the
See,
six
as a writ court, we are not obliged to reappreciate. It is a matter of compassionate appointment, therefore we are doing so. Now come to the next criteria.
my lord, the basic pension, my lord. My lord, that will appear in 57. Relative merit points to be awarded in respect of monthly family pension. Slab have been given up to 4,015, between 4,001 to 5,014, and thereafter the number goes up.
Where
My
is
lord,
that assessment inter-se merit that you were just showing?
Page 57, my lord.
No, no, the other document
The
that you were showing.
Assessment, my lord.
Marks awarded to all the candidates.
Page 80.
Page 80.
880, my lord.
No, that is not it, sir. Just now you were showing where 10 marks have been awarded to the other.
My lord, page 80, my lord. Marks of
Last page of supplementary. Last page of supplementary. T20. Yes, what is the second criteria?
basic pension, my lord.
Basic pension.
Pension. Petitioner was awarded 8.
Which page?
My lord, that will corroborate from page 79 and 80 of the writ petition.
No, no,
Page
where is that criteria prescribed in the circular?
57, my lord.
Point number Roman 2.
Roman 1, my lord. Slabs of basic pension or family pension. Basic pay of family pension.
Yes.
Lord, up to 4,000, it was 15. So I have been awarded 8. Based on that, the family pension of my case was 7, falls between 7,001 to 10,000.
10,000. Yes, already.
Whereas, my lord, the lastly two appointed person, Sushila Devi and Renu Singh, have been awarded 15. 15 can only be if it is up to 4,000. Now, my lord, kindly come to page 80. Answer B to the RTI reply. Minimum family pension as on date is 9,000. So 4,000, my lord, was not even applicable at that point in time. So either the marks of the lastly two appointed person has to be carved down from 15 to 8, because the minimum family pension was 9,000 at that relevant point in time.
When has the appointment been granted?
My lord, I beg your pardon, my lord.
When the compassionate appointment has been awarded to these persons?
My lord, that will reflect from page number 79. Sushila Devi was between 10th August 2016 and 31st December 2017.
When they have been appointed on compassionate grounds?
My lord, I do not know the exact date because the reply
between
corroborates
16 to 17.
17, my lord. Between August 16 to 31st of December 2017.
So therefore, we don't know what was their pension on that date.
But my lord, the last year revised pension, as after the pay commission, was moved up till 9,000. So there cannot be any situation.
But
if
we
my
don't know when it happened. At the time of their consideration, what was their salary, the pension, family pension, we don't know. This they are giving as on date. This is not the at the time of consideration.
My lord, I'll show, my lord. My lord, this is one of the minutes of the meeting which was communicated to me by the respondent authority. Starts from page 43A and thereafter 44A, my lord. The CAC met on 28th of February 2018 in the chamber of such and such,
You are referring to which page?
page 44A.
44A.
44A. My lord, from the 1, 2, 3, 4, 5th paragraph, the line starts with observation.
A. Type copy.
Type copy.
Yes.
The 5th paragraph start with the word observation.
Yes.
The CAC meeting has been convened to grade the eligible candidates for compassionate appointment for the vacancy year 2016-17. It was learned from the file there is only one vacancy of post 2 of MTS exists for the year 2016-17, and it has been approved by such and such, dated such and such for compassionate appointment and the self-contained note. The committee has also observed that such and such, the committee was provided grading sheet with a list of 40 applicants for this post. It was about the 31 from serial number 1 to 31 applicants have been considered for grading in the previous CAC meeting for compassionate appointment for the year 2015-16, whereas 8 applicants of serial number 3240 are fresh entrant for consideration of compassionate appointment, including Sri Rana Mukherjee for the said vacancy year. My lord, total 40 candidates were there. There are some discrepancies. So at that point in time, through this letter, I have been asked to resubmit my documents and I have been treated as a fresh entrant. So my candidature was considered as per the speaking order passed by them. My candidature have been considered with these 2 candidates also, Renu Singh and Sushila Devi. At the same point in time,
They were there also. How do we know? They were there or they have been there from before. How do we know?
because my lord, it was their reply that Renu Singh and Sushila Devi.
Where is that? Only 32 to 40 are fresh entrants. Up to 31 are all old entrants.
Look,
we cannot see that between 32 to 40 these 2 persons are there, and even if they are there, then this is for the year 2016-17, and the information which has been made available to you under RTI is 2019.
because my lord, at the time of consideration,
There is no material to show what was their salary, family pension at the time of consideration.
well, the family pension, as per their saying, it was 9,000. It was come down to 9,000, my lord. The 2016-17,
Again, we are saying, see, you can keep on repeating the same thing, or you can clarify the court's query. It is up to you.
my lord,
We are asking you, what do you have? You got the material to show what was their family pension at the time of consideration?
no, my lord, I do not have the material.
So these 2 parameters, which is the other parameter?
So thereafter, my lord, from the bottom, unemployed and married widow daughter. In the circular, it will come at page 60, my lord.
Yes, how is this relevant?
My lord, I have been awarded 3,
Yes.
whereas my mother was surviving at that point in time. My lord, if there is only 1 person, then the marks has to be 3. If there is 1 person who is physically handicapped dependent, then it ought to have been 5, my lord.
You have been awarded how much on this parameter?
My lord, 5 instead of 3.
It is serial number.
Serial number, my lord, 8.2 at page 60. In that, my lord, from the bottom, fourth column, my lord. The third column, my lord.
Number of dependent.
Number of dependents.
Unemployed and unmarried.
Unemployed and unmarried.
You have been granted 3, not 5.
I have been awarded 3.
Yes.
But since I am the petitioner himself is a physically handicapped person, ought to have been secured 5, my lord.
Why?
My lord, page 60 will clarify that portion.
No. That does not say so, sir.
My lord, 3/5 in case of minor
Children
or physically handicapped dependent.
Yes. You are yourself the beneficiary. It is not that there is another physically handicapped child or dependent.
My lord, kindly, if you lordship be kind enough to look into the portions 8.2
Again, we have-
relative merit points.
You will not get because you have not applied as physically handicapped. You have not shown.
But they
You
have
have failed to show. Therefore, this also is for the same ground. The first point was unsustainable. Which is the other parameter?
thereafter leftover service.
Yes.
The leftover service.
At which page?
My lord, page 45. I have been awarded 2. My lord, has to be tallied with page 60. I ought to have been awarded 4 because I will fall under the bracket of above 5 years and up to 10 years. In terms of the order passed by this High Court that my age, the age of superannuation of my late father has to be treated back in the year 2002.
Where is that? Show us from the order.
Page page 27. So the order starts from page 25. Page 27, second paragraph. In this case, the first application for voluntary retirement was made on 7/3/2001. The respondent did not pay any heed to this application, and thereafter the petition number 1 had to submit fresh application again on 2 occasions. It was only after
Sir, the direction is at page 28. Don't read the narration of what has happened in the past.
Page 28 is regarding.
Therefore, set aside the judgment and then the direction the respondent will consider from there.
My lord, this is the operative portion of the order.
This is the direction.
This was the direction.
Yes.
But my age bracket, whether my father retired prior to 55 or not.
That is, where is that in the direction that it has to be considered? Treating that he has.
My lord, just over and above that page 28 itself. In our opinion, the decision of the respondent to reject the candidature of the petition number 2 for compassionate appointment because his father was
Not correct. It has been set aside.
That has been set aside.
Now, what is the direction?
My lord, consider my candidature.
So let us see whether there they say that it has to be considered as on that date. You said the order has said that it has to be considered as on. You are trying to draw this out by inference that since it has held it to be wrong, therefore it should have been considered.
Possibly, I have failed to make myself understand.
We think so, yes.
My lord, initially when my candidature made by my father was rejected, that was on the pretext that my father
was delayed because it was the third application. By then he had crossed 55 years. The court said it was because of the delay on the part of the respondents. It should have been considered while he was still 55 years. Therefore, they have set aside. So, any difficulty? We have not understood what you said. We have understood. Now, pursuant to this, where is the court's direction that it has to be considered treating him as 55 years?
Takes me back to the year 55.
Just show the direction. This court's order is not open to interpretation. A court's order is what it says it is. Now, let us see from the order that it says it has to be because the court has given specific directions. If it was of the opinion that you are to be considered treating your father's age at 55, it would have said so. We don't find it. You are trying to make out from a holistic reading of the order that no, the court has held it was bad. It has. But there is no consequential direction to that effect.
If I'm allowed to say this, my lord,
Yes.
in an event, if my father was not treated in the age bracket of 55, then I wouldn't have succeeded in the first place. My candidate.
But that claim is not being considered. That is what we are surprised to see, and you have allowed it to remain like this. You could have pursued the matter that I am entitled to consideration in terms of that circular because I was wrongly denied. But that's not the case. The court says, yes, you were wrongly denied, but now you have to be considered as a compassionate appointment in terms of the relevant circular. So you cannot have both.
My lord,
You have agreed to this. It was at this opportunity that you could have taken up the issue that no, we do not accept this. We must be granted what has wrongly been denied to us. You have not.
Well, if I'm allowed to say this, my lord, if my father crosses the age bracket of 55, then I wouldn't have been allowed to participate in this compassion.
Now you are being allowed because he has died.
No, my lord. Prior to this only.
Yes.
Because
What is his date of death?
2007, my lord.
Yes.
No, not 2007, my lord.
He has died. At that time, you were eligible for.
Well, 19th of January 2017.
Then?
Well, this order was passed on 10th of August 2016.
Which order?
The order passed by this High Court, my lord. 10th of August, page 25, 10th of August 2016.
What is his date of death?
10th, 19th of January 2017, my lord.
Oh, it is 17, not 16.
Not 16, my lord. And my lord, even in the cause title also, which will appear from the order, the name of the father of the petitioner is there. Aurobindo Mukherjee. But after passing of this order, the father passed away.
All right. Yes, that substantially changes the issue. So you say that he should have been considered as being 55 years.
As being 55.
And that would leave him with how much? 5 years?
5 years.
And what is the marks eligible for 5 years?
I ought to have been secured 4.
Where is that?
Page 60.
Page 60.
60. 8.2F, serial number 4. Above 5 years and up to 10 years, marks to be awarded 4.
But up to 5 years it says 2.
Up to 5 years it says 2.
Yes.
So 55, I has to apply before I attain the age of 55. That was the policy. Once I cross the age bracket of 55, I am out.
So that means you are below 55. Therefore, it has to be above 5.
Above.
That is what you are saying.
That was what.
So this aspect has been considered by the tribunal?
No, my lord. I'll come to that.
Where have you raised this issue? This is the only issue then. What is it? And if you get 2 more additional marks, how does it change the outcome? If we say that yes, instead of 2, you are to be awarded 4.
Because my lord,
Then how does it
13
change?
parameters. Now, out of this 13 parameters,
if you get 2 more marks, what will be the total marks?
These are only 4 to 5 parameters which I found or entitled to know, like what marks they have obtained.
All right. So therefore, we are considering on 3, we have not found anything. We are being very open to you.
No,
this is the 4th ground. We are finding that you may be able to get 2 additional marks. How does that change the situation? Let us
because
see.
my lord, kindly come to this terminal benefit monthly income. What benefits they have earned, we are not entitled to know.
Sorry,
we do not know what
we will not allow you to go into that. We are being very clear.
My lord,
you cannot.
The way the mode and
First
manner.
Come to this. After these 2 marks are awarded, how will it change? We cannot embark on a scrutiny of all the candidates' marks available on all the parameters.
Well,
that is the scope of a writ proceeding.
Well,
under Article 226.
My case is that, my lord.
Tell us, is it the scope? Is it open to you to argue such a thing?
My lord, if I'm allowed to say, my lord, if there is illegally, it has been considered, my lord.
Cannot be done, sir. We'll deal with your submission. Don't worry. Yes.
My lord, thereafter, my lord, the education qualification, the very last parameters.
No, but these 2 marks, what is the difference between the candidate selected and you?
Well, it will grant me 2 more marks. That is all, my lord.
What is the difference between the last candidate's marks and you?
My lord, last candidates, my lord, has obtained 6, 8, and 4 respectively, whereas I have been obtained 2.
6,
If-
8, and 4. Who is the last candidate?
My lord, lastly appointed person, I don't know the name, it's 4. It will reflect from column number 5, my lord.
Acha. So what is his total? His or her total? Eight, 66, 72, 6, 81. It is 81. Mhm. And according to you, as per the relationship with XGS, you should have been awarded?
My lord, in my case, it ought to have been 4.
4. You have been awarded 7. Relationship with XGS.
Relationship, my lord. Relationship, my lord, I ought to have secured 8 or 10.
How can you say 8 or 10? You
My lord,
have
I
to say
know-
1. Either 8 or 10. You cannot say 8 or
Because,
10.
my lord, the language of the circular,
You have to make a specific claim.
my lord, because in both the columns, my lord, at page 55, the first column says unemployed spouse or physically handicapped son, daughter, widowed. So I, being a physically handicapped son, I ought to have secured 10. That was my first thing. And similarly, in the second Roman 2, own daughter, unemployed and unmarried, widowed, 1 additional point shall be given if he is physically handicapped.
You are a daughter.
No, my lord. Thereafter, the
You are
language says
unmarried widow.
if he is physically handicapped. I don't know whether it can be considered as a typographical error or not. My very best case is I ought to have secured 10. If not 10, then I ought to have secured 8 plus 1, 9.
So let us take it at 10. You
Yes.
claim 10. So if and then 10 here, and in this you say you should have been awarded next one you are claiming how much?
Next, my lord, in this thing, my lord, basic pension.
Basic pension, how much you are claiming?
My lord, my calculation is correct because I was getting 9,008. The second 3%,
So therefore that according to you is correct.
my marks is correct so far as basic pension is concerned. But their marks of 15 and 14 respectively ought to have been come down to 8 because considering the minimum pension at that point in time was 9,000.
And then
Thereafter, my lord, unemployed and unmarried daughter, widow, I ought to have secured 5. So far as leftover service is concerned, I ought to have secured 4. And the last column is concerning the educational qualification. That will appear at page 62.
Yes.
My lord, the minimum educational qualification starts from SSLC 10th standard Madhyamik ITI. Relative merit points to be awarded 5. I am a Madhyamik pass. In that event, I ought to have been secured 5. I have been granted 4. The rest 2 persons.
You are being considered for MTS.
No, I have been considered under 12th standard.
You have been considered for the post of multitasking staff. What is the pay of the multitasking staff?
$5,200 to $20,000.
Therefore, below graduate, you are to be awarded 4. Come to the bottom of that table. What you are relying upon is if you were being considered for a post carrying a pay grade of 1,800. Therefore, that is hardly applicable in your case.
My lord, even if assuming I have secured the right marks of 4, in that event, the rest of the 3 candidates, 2016 and 17, they have been secured 0. And the reason adduced by them is their educational qualification, they are 7th pass.
So,
that is page 82.
yeah, that is reflected from this also, your supplementary. That is reflected in this table where you have given this page 45 of your supplementary. They have been given 0.
They have been given 0, whereas the lastly appointed person,
Yes.
he has been awarded 5, despite he has qualification, my lord, up till.
You don't know his name. How do you know his qualification? Just now you said you don't even know his name. How do you know his qualification?
From the RTI reply, my lord, that will appear at page 77 and 78.
So RTI reply does not give his name.
No, my lord. Page 77, 2 numbers of compassionate appointment committee meetings were held. Lastly, compassionate appointment being held on 10/4/2018. Since 2017, 2 persons were appointed. 1 candidate has been selected for compassionate appointment and marks obtained by hearing as follows. This is the lastly appointed person's marks. Educational qualification, he secured 5. In the next page, the marks obtained by the petitioner is there. He has secured 4. And thereafter, my lord, commonly come to G. That is the
educational qualification is in which column?
My lord, in the circular.
No, at page 77.
At page 77, the very last column, applicant's EQ.
Achha.
That is the educational qualification. 78, the marks obtained by the petitioner, that is 4. And thereafter, my lord, G is in relation to the date of appointment of the lastly appointed person. H is in relation to the what is the minimum age educational qualification. The answer is there is no bar in educational qualification in compassionate appointment scheme.
Where are you reading?
At page 78, my lord.
Oh, that is your assessment.
This 78 is my assessment.
You have got 4.
I have got 4. 77 is the person lastly appointed.
Yeah.
He secured 5.
Correct.
His qualification will reflect from column I at page 78, past class 8.
That is your.
No, my lord. I'll corroborate with the exact questions which I have written, and that will come from page 74, my lord. This is my RTA query.
This is a response to this query.
This query, my lord.
Your query I is not there.
My lord, sorry, my mistake, my lord. It's page 69, continuation up till 70, my lord. These inform me the educational qualification of the lastly selected and appointed candidate under the compassionate appointment scheme. Now, as against that, they have given a reply, the educational qualifications class 8.
Yes.
So these are the following aberrations. What have been?
So what difference does it make if he is yet passed, then?
Well, either, well, to my understanding, the basic minimum qualification is 10th standard. Well, if my understanding is incorrect, then up till 10, any person ought to have secured 5. Either in that event, my lord, Shushila Devi and Renu Singh ought not to have secured 0, since they are 7th, they have qualification till 7th standard.
Seventh and eighth is a big difference, sir. Seventh and eighth is a big difference.
But the circular does not state whether it will be 7, 8, because the minimum qualification starts from class 10.
There is no minimum educational qualification.
The slab which they relied on their circular.
There is no minimum educational qualification that they have responded to your query H. So don't say that there is a minimum qualification. There is no minimum qualification. That is in response to your query, just above the query that you have placed. So you must be aware of this. So don't say that there is no minimum qualification.
My lord, in that
There is no
event,
minimum qualification.
my lord,
Why are you saying minimum qualification?
if there is no minimum qualification, my lord, then these 2 persons ought not to have secured 0.
We don't know, but that is as per the criteria specified. Although there is no minimum qualification, there is a particular method of awarding marks because there has to be a scrutiny.
My lord.
The number of seats are limited. It cannot be that everyone will be treated by the same parameter. That will not come in the way, but that will surely be a relevant factor for the purposes of empaneling them, for maybe making available the 5%.
With all due respect, the parameters has to be within the guidelines of 2015 itself.
2015 guidelines you have brought.
2015 guidelines form part of the record, my lord.
Oh, that is what we were just seeing. That is what we were seeing. Right.
Start from page 51. 51 is the type copy. Good. If I am permitted to take your lordship to the reply submitted by the respondent authorities before the tribunal, my lord.
You have been considered in 5 transactions.
After 26, as per the
You are referring to only 2.
Lord, I have stopped because at the intervening period, my lord, the contempt proceeding was pending. So there, if I'm allowed to say this, my lord, this won't improve my case. Look, 3 consecutive years. Well, kindly come to page 6 of my supplementary affidavit. Their reply I'm relying upon.
You are comparing the inter se merits as if this was the only transaction. There are 5 transactions.
There are 5, my lord.
Then why are you unnecessarily wasting the court's time? You don't have the detail of all the 5 transactions.
Well, they also failed to brought this before the record. my lord.
They have failed, then they have failed. You don't have it. That is a matter of fact.
My lord, the
You have
person,
not come here for a direction to them to make available the documents. That is not what you are here for.
no, my lord.
So therefore, there is no point in saying that they have failed.
My lord, my candidature ought to have been considered in the year 2016. That was my case.
It has been considered 5 times from 2016.
But this is not a just consideration, my lord. The consideration was not proper because they are saying in their reply,
not read the order first, therefore. What else you want to say?
Kindly see.
Wait, sir. Wait.
CAC minutes.
Wait, sir. Yes.
my lord, page 6 of their reply in my supplementary.
What is it? Tell us.
My lord, their,
Records.
my lord, their averments, my lord, likewise, when they are dealing with my allegations in the petition, they are saying likewise on 8th April, the authority concerned intimate the applicant that the compassionate ground for the year 2020 as per guideline and rule on compassionate appointment in GSI committee has been considered. Your name was not recommended for compassionate ground as he secured less merit point than the recommended candidate, and in the said letter it is further communicated that such and such reasonable period of 5 times is over. So they are only harping on the word that I have obtained time and again I have obtained less relative merit points than the other person.
Yes. What do you have?
Petitioners have appeared 2 times, consecutive 2 years, my lord. My land expense land is not the zone of the consideration regarding the among the compassionate appointment candidates. Kindly see the marks allotted by the 2016-17 and 2017-18.
Where is that? Where is that?
That is the flag marker, my lord. This is the marker. I have, my lord, kindly see page 2016-17.
This is part of the record.
Part of the record.
No, my lord.
I have handed over the records from the department.
No, this is part of the CAT records.
No, CAT records, my lord. I have High Court's report only for showing the High Court's, my lord. Department has supplied me the records.
This was never supplied. This does not form part of their reply, my lord. Before the tribunal.
Department has.
Not required. We are not going to this. We have not asked you to give this. You keep it with yourself. You keep it. We have not asked for it. You keep it with yourself. Yes, you take it back. We don't want to go into anything which was not before the tribunal.
The marks have been allotted in what manner? That's why, my lord, I have produced the records. Department has produced. It is not my own.
Item number 12. Item number 13. 13. Item number 13. Well, I am for the petition. Well, so as you heard it, my lord, it is in respect of the promotion given, seniority maintained, but the pay scale not given, that is, my lord.
Yes.
My petitioner before lawsuit was appointed when he was a commerce graduate. He was promoted thereafter as a fuel checker in 1994. And he was absent for a few days, then one increment was stopped. Non-cumulative. Non-cumulative money, he got back the same in next year. So there is no deficiency in the salary. And thereafter, in 2005, he was dismissed from service due to unauthorized absence. Then appeal paper, petitioner said that the calculation of the time, including the calculated the time, which was earlier already got one increment stop. So it was written, it is not the correct. I got one punishment. Again, my lord, he said that I went to join, but you did not give the proper medical memo. As such, I could not join. My lord, as the appellate authority, after visiting the dead, my lord, reinstated and with regularized the service. That is, my lord, at page 51. Not 51, my lord, regularized service.
The last order in your favor was order passed in the writ petition in 2008.
2008.
10/4/2008.
My lord.
Order passed in WPCT number 84 of 2008.
That is why by the honorable this court, since, my lord, I prepared appeal.
Where is that?
No, read before this honorable high court. At the time, my lord, I was given.
Where is the order? 10/4/2008 order.
That order is, my lord. Page 62.
68 page, my lord.
62 or 63.
68.
Yes. This is my like liberty given to file the fresh way. That is my like before lawsuit. Because I preferred read, and that by that time I was.
Which order was, what order was passed, which has been taken note of in this order?
2008 order.
Yes.
Under what happened, I was not
It
given.
is referring to an order passed by the department already.
Department promoted me.
So where is that order?
Promotion order. Promotion order.
Promotion order is 65. 65.
Promotion order.
This is a subject matter of the application before the tribunal.
64. Page 64. Pursuant to the judgment of the Honorable CAT in way number 1083, 7/1/2008, on being the found suitable in the modified seniority list for promotion to the post of clerk grade 1. I was in grade 2, that's junior clerk, senior clerk. Till to white office order number 29/2/2008. Sri Orijit Tagore, clerk grade 2, under section Indian law code Namata, rupees 5,000 rupees, is promoted to the post of clerk grade 1, however, that is strongly typed, my lord. Pay scale 4,500 and 7,000, and with effect from 29/4/2008. 2005, that is from the date of promotion of his junior, Mr. Sri S.K. Sinha, clerk grade 2, under Loco Malda for former basis, and actual mandatory benefit will be admissible from 29 to 2008 from the office of the publication of result. There is no result, Malda, because it was promoted. There is no election, only the vacancy as for seniority promoted, Malda. That is. I was Malda, then Malda I claim Malda the. But this EAT application which I have plus 16 in page 25, 65. I'll also can come to page 52. Provisional combined seniority list. 52. That is provisional combined seniority list of ministerial staff of carriage and wagon.
The reinstatement order of 2005.
Yes, that also. Before that, my seniority position process kindly come to page 54.
Where is the reinstatement order of 2000?
That is that page
49%.
Page 49, 50.
Page 49%.
50.
49, 50.
Yes, A5.
49.
49.
49.
Annex of A5. Order dated 3rd October
And the
2005.
dismissal order?
Dismissal order, before that. That is the page 45. Page 45. After considering the findings of the DNA inquiry is respectable. First para, that is last 2 line, shall be dismissed. Remove, not dismissed, remove from the service as a disciplinary measure, and the same will be effect from the date, immediate effect. Lastly, if you want to make appeal against the above penalty, you can do so within a period of 45 days. That I preferred appeal. That is my page 47. I preferred appeal. I said, that in appeal that the charge sheet from the showing that the unauthorized is absent for 17 November 1999 till the date finding the punishment order is not correct. 1. Since I went to join my duty on 26th April 2001. Accordingly, my case was referred to the senior DME. He asked me to produce the certificate from the police section, and that no case is pending against him and also I was given the wrong medical note that I also stated. Then reinstatement order at page 49. Last amendment, the period of absence is to be regularized with leave as due to him. The fuel inspector is nominated to monitor the performance. So my service was regularized. That is page 49. So there is no matter break of service, anything. Matter. And that was done as per the order of Learned Tribunal. That is at page 50, my lord. Learned Tribunal directed to consider it. Criminal losses kindly come to page 54. Page 54, it is a seniority list. Of ministerial staff, my lord.
There is no dispute of seniority.
Yes, my lord, that is, my lord. That is, my lord, yes.
There is no dispute of seniority. You are claiming that you are above Mr. Sinha, and therefore, following the next above rule, you should have been promoted.
Promoted.
That they have done. So there is
they
no
have- they have
dispute
given
on
the-
that count. Only dispute is you are claiming salary for that period.
Yes.
Areas.
And my lord, the
Whether you can be granted any salary.
step up from the date of my given promotion, even the notional benefit, notional promotion.
Notional means notional. Notional does not mean actual.
But Honorable Supreme Court said,
Let's see.
that is my lord, so. And my lord, losses can have showing another, my lord. Another losses
judgment
can
you are-
before going to the judgment, losses can see my supplementary affidavit.
Yes, what is it?
Supplementary affidavit, my lord, that is losses can see in the prayer. I was promoted as a office superintendent, gets 2, my lord, and my position is above my juniors SK Sinha. SK Sinha
That is
already
not in dispute. They are not disputing that. Why are you saying that? They say you are senior because he has been promoted. They have promoted you.
Yes, my lord. Losses
From the
can-
same date, from the with effect from
my lord, losses
2005,
can
with effect from 2005, giving actual benefits from 2008
Eight.
because then you were reinstated. And past service, they have said that you cannot. It is notional, nothing.
my lord. My losses can then supplementary to once, my lord, losses see.
Yes.
Once. My lord, losses can see the supplementary affidavit. Yeah. Audit Tagore, who is getting 15,580. Another promotion from senior clerk to office superintendent. Head clerk, that is, my lord. Sumir Kumar Sharma, who is
That is
number
not
two.
the subject of the present case.
My lord.
Your case is confined to the promotion which was granted to Mr. Sinha in 2005.
Yes.
That they have granted.
Second, and even 2008, my lord.
No, that is not part of the record.
Yes, my lord. Yeah.
That is not your. That was not your case before the tribunal.
My case is not a step up as per my
Step up as per Mr. Sinha that they have
Yes.
given. Now every subsequent stage it will follow. For that every subsequent stage an order is not to be passed. Your grievance only here is that for the period which they have allowed notional, whether you will get actual or not. You said Supreme Court says yes, during notional period I will get actual. Let us see where the Supreme Court says.
I have submitted earlier 2 judgments, not in that bundle, my lord. I have given for that is my lord, 1, my lord. That is 1, my lord. In one of India versus P. Jagadish and others. Only here, my lord, the process can you see para 6 and 7 judgment is there. I have given earlier. P. Jagadish and others. There is I have not in that bundle, my lord, separate I have given earlier occasion.
Again, you are on the stepping up principle. That is, stepping up principle is not your grievance that they have granted. Whether you will get the pay for that period or not, that is the only issue now.
No. My there is.
According to you, Mr. Sinha has been granted the promotion in 2005.
Yes.
They have granted you promotion with effect from that date.
Yes.
Your stepping up has been done. That is not an issue. Whether you will get the financial benefits from 2005, that is the only issue. You were out of service. You were reinstated.
Yes.
So still you will get it, you say. They have granted notionally. You says notionally means actually, as per Supreme Court judgment. Which judgment says notionally means actually? Let's see.
My losses can come to my pair B. My pair B of REIT. My pair B in the REIT application at 15.
No, come to the OA, not rate application. Rate will not travel beyond the OA. Come to the OA. What was your prayer before the application, before the tribunal?
In REIT, I can
come to page 39.
Like the respondent to give effect of the promotion order from the clerk Z1 on registration and fix the salary.
Salary, that is what we are saying. Your only
fix the
grievance.
salary.
Your only grievance is you want salary. It's not
Salary.
that you have not been stepped up.
Salary at per admitted seniority position above his junior.
Yes.
That is this called stepping up under.
So only salary.
Salary admitted seniority position above to his junior. So, my lord,
Now
by
that has
amending
the tribunal. Now what the tribunal has granted, let us see.
tribunal has not granted.
Tribunal has not granted anything, but the authorities
Since
themselves.
said since you are dismissed and you lost the.
Correct.
I got punishment.
But come to page 49, see what has been granted.
That is 49 is the reinstatement.
Yes.
My lord.
Yes.
My service has been regularized.
Yes.
So there is nothing, my lord. And the department, it is not the authority.
When it has been regularized?
My lord, it is 3rd
October 2005. When Mr. Sinha has been granted the promotion?
My lord, in 2005.
Oh, give the date, sir, please.
2005.
It is before your reinstatement.
Maybe.
No, that is a relevant fact. What is the date? Maybe you is a different thing. Page
62, 63.
62.
Promotion order.
62 is the order passed by the CAT.
64. That then they have considered CAT as per CAT order. In pursuance to the judgment of the Honorable CAT, that is order. So order promotion was given
29/4/2005, Mr. Sinha has been granted. 6 months before.
That time I was not in.
You were not in service.
But after regularization of service, whether I am service or not.
Now this
service has been regularized.
Yes.
So nothing remains.
Yes.
And the department has said that you will get benefit of notional benefit from 29/4/2005.
What
They have
was
not
the
said that
what
after his
was the entire period of absence? What was the entire period of absence?
Pardon me.
What was the entire period of absence?
Entire period of absence, according to me, 1 year. 1 year.
Entire period of absence.
Absence. But they have calculated 4 years. Then I preferred appeal. Then they recall the order. So anyway, my lord, I was got.
They never recall the order. You have been absent till the date of dismissal.
Till the date of my lord?
Till the date of dismissal, you were absent from November 1999.
That is their, their departmental proceedings.
That departmental proceeding?
I went to join. Let's just kindly come to page.
Oh, those things cannot be reopened now at this stage. What the fact are already over. In 2005, dismissal was passed. They said you have not joined till date. You are dismissed. You preferred an appeal.
My lord,
You preferred an appeal. You said that I am suffering from some mental problem. I am having too much of issues at home.
I have
The
to
appellate
busy with my
authority said,
parents' treatment
all
and
right, we are taking a lenient view. Will you regularize as per leave available to him? Now, regularize what? Regularize the entire absence from 99 to 2005.
99, that 2000.
99
punishment
to
I already got.
2005.
99 punishment I already get on increment stuff.
No,
So
no,
they only calculate.
that was for 1 month absence. That was nothing. That was 1
Yes,
month
that
absence.
is
That
one
is over.
increment stuff.
That is over.
That is,
This is from November 99 to 2005.
my lord.
This period of around 6 years.
In between that, I went to join my lord.
For those 6
2001.
years, this is the treatment that is to be given to you, page 49. That determines your right for that 6 years.
No, my lord.
And this is not under challenge.
I have said my losses can come to pay. Ye para.
Please come to page 49. Humanitarian angle in this case, the staff is given a chance to improve. Case is reviewed. He is reinstated in existing grade. He was holding. Period of absence is to be regularized with leave. This period of absence means from November 99 to October 2005.
Yes.
Yes. So November 99 to 2005. How much leave did you have that you will get salary?
But at that time, my lord, I am getting lesser pay. Certainly lesser pay than my junior.
We are not on pay.
My lord.
This order of reinstatement comes with a direction to regularize the period of 6 years with leave due to you.
But I was been regularized. I was given seniority. I was been.
We are not on seniority.
My lord.
We are on regularization with leave. How much leave can an employee have for 6 years?
My lord, I was
impossible.
Without pay for some time.
So therefore,
Without pay, I lost the increment.
Then how
I
can
think all the losses can be said. So I
if
got.
you are without pay, how can you get salary for that period?
I am not asking for salary.
You are asking for salary. That is your claim. You are asking for salary. You are asking for salary.
Salary at par with my junior.
How can you get when you are on leave without pay? That is what we are asking you.
I'm submitting. I was
cannot get.
I'm submitting. I got punishment. I am getting lesser pay, my lord.
Yes.
So that is my punishment, my lord. And that is over when my service has been regularized. And I have given seniority, my lord. I have given seniority, and as per seniority, my promotion was given. This order was passed, my lord, by the authority that your notional benefit from the 2005 when your junior was promoted. This is not my order, my lord. Not the order of any court. This is the order of the authority, my lord. So authority accepting my service on that day also. Authority accepting my service on that day also. And one thing, my lord, I was punished. Will the punishment will go in next, my lord, after reinstatement regularization? Then it is double jeopardy, my lord. So my submission is that I got my department has regularized my and I'm given promotion when I was not in service. It is department. I have not done it, my lord. So, and department has not contradicted it, my lord. Last kindly come to page 5859 on letter from the DPO.
Yes. What are you
My
saying?
respectful submission is this.
What are you? Which document you are showing?
I lost it at page 58, 59 type copy. I make page 59, A5, A9. Internal page 35. 59. That was later of the Senior Divisional Personnel Officer. In reference to your appeal received through Mr. Ranjan Chakraborty, no, it is Chittaranjan Chakraborty, I am. Chittaranjan Chakraborty, my lord. Advocate High Court, Calcutta, in 28/8/2006, it is intimated that Sri Somir Kumar Sinha, Clerk Grade 1, under AC Loco Malda, although junior to you, has been considered for promotion to the post of Clerk Grade 1 on restructuring in terms of the senior DPO's Malda, way number such and such, and under PO number such and such, dated 29/4/2005, while at the material time you are not in service under the punishment of the removal from radio service for your unauthorized absence, and as could not be considered for promotion against the restructuring. Further, on applying, you have reinstated in service by appellate authority on 20/10/2004 in terms of the letter dated 3/10/2005, regularizing the period of absence as leave due by the appellate authority. However, you will be considered, last paragraph, you will be considered for promotion to the post of Clerk Grade 1 in scale of 4,500, 7,000, as and when the vacancy will have filled up, and the benefit will be given as per rule.
And that has been granted to you at page 64.
Page 64, I have been granted.
Yes.
My lord. My lord, from which date I was given granted? My lord, that time I was not in service. According to law.
You were without pay.
Well, I was without pay.
And you want
I was in.
And you want salary for the period when you have been regularized as being without pay.
My lord, I am submitting, my lord.
Whether you can get, that is the only issue.
My lord, I am submitting, my lord. I am not whether that if you are excluding that period. Even the promotion was given 29/2/2008.
No, with effect from the date of Mr. Sinha.
Yes.
So that is not.
So I will get the from that date, and the, my lord, from at least 29/2/2008. Actual benefit, my lord. Losses, kindly see the page 64. Page 64, 1 second, my lord.
Yes.
My lord. From fourth line I am reading, my lord.
Yes.
He is promoted to the post of Clerk Grade 2, this is Grade 1, rupees Ato, 29/4/2005. That is from the date of promotion of his junior, T.S.K. Sinha, Clerk Grade 2, that is wrong also, under locomotive department performance on the basis and actual monetary benefit will be admissible from 29/2/2008.
Correct. That is the date of issuance of the order.
So, my lord, I am submitting one thing. That my service
So
was
you are saying from the date of reinstatement.
Reinstatement, and my lord, one thing more, my lord, that I cannot get, that is Supreme Court said, I cannot get the lesser pay than my junior, if even my position, increment position is lesser than my junior. Even then, Supreme Court said, man. That is not, and they have to stay for at least at par with the junior. That is also not given in spite of it. That's why I preferred the writ of it. Losses, kindly come to. To the manner that is there. Hello, losses, kindly.
Where is the reinstatement order?
This is page 64, my lord.
Page 49.
49, sorry, 49. I already got punishment for absence. That punishment I got, my lord. My service has been regularized. Again, I will be punished, my lord, when I will getting promotion. When I am at par with the Mr. Sinha.
Yes, at least from
Mr. Sinha, I am getting less pay. I have nothing to say.
From 3/10/2005, that is the date of his reinstatement.
That day, yes, if you
from that day, why he is not to be granted?
That is my, thereafter, my lord, even I have promoted with effect from 2008. That is also not given. And Supreme Court, if
No,
he is
from
getting lesser
2008
pay,
From 2008, they have given you.
no, Mala, not given.
Yes.
Allah, just kindly come.
Monetary benefit admissible from.
I am getting at least 3,000 less pay than the.
Oh, that's a different thing.
I mean, in promotion,
No,
in clerk grade 2, junior clerk, I am getting less pay than my junior. That is, I am not claiming. I cannot claim because I got punishment due to my unauthorized absence. I got. That is, I am claiming. That punishment I got. When you are promoting me as a senior clerk, that time alone, even I was awarded for my service.
Why he has not been granted from 3/10/2005?
Yes, my lord. Yes, my lord.
3/10/2005, you have reinstated him. Past, you have said will be as per leave available. But from 3/10/2005, he is entitled to our benefits. No, prior to that, he may not be.
He has joined his duty on 2010-2000.
Huh?
He has joined after reinstatement. He has joined his duty on 20th October 2005.
So from 20th October 2005, why he should not get?
My lord, I am a little slow, but I'm satisfied.
Yes.
Prior to that, Mr. Sinha was elevated since he was not there. He has been getting salary in his feeder post where he has been allowed.
All those issues have not been raised by the respondent. Don't raise issues which your respondent has not raised. These are not facts on record. Neither of the respondent has said this. Don't make up something right now. This is not a reason assigned by the respondent. You cannot assign a reason which is not assigned by the respondent. Feeder post and those posts, that is not there.
My lord, kindly allow me. My lord, I can understand, my lord, the whole day, my lord, is listening of everybody's contention, so my lord, but my lord, I have to make my submission in an humble way, my lord.
You do, but you have to confine your submission to the pleadings, not beyond that.
That's true.
That is what we are trying to say. Yes.
My lord, that is the catch. He has been reinstated.
Yes.
Reinstated in which post?
It is apparent from the order. Come to the order, page 49.
Yes. Yes. Yes, my lord. Page 49.
Yes.
On review of the performance prior to this, in view of that, improve upon accordingly in case reviewed, he has the existing grade.
Yes.
He has the existing grade.
Yes. What was the existing grade?
We'll check out.
Yes.
Thereafter, my lord, he has been promoted to charge grade 1.
By which order?
Bracket 1. By order of page 64.
64. Now clerk grade 1, he has been promoted. Clerk grade 1. He has been promoted to clerk grade 1 or clerk grade 2.
Clerk grade 1.
So he has been promoted to clerk grade 1 by 64. That is the next higher post above fuel checker. Now why he has been promoted to clerk grade 1?
Fuel checker is junior clerk.
Please.
Junior clerk.
Please.
But, my lord.
No, because what the order says, come to the order.
Yes. My lord, order, my lord, referring at page 64, my lord.
Obviously, that is the promotion.
Yes.
Yes.
In pursuance to the judgment of the Honorable Court, Calcutta, this and being submitted, post of clerk grade 1 in skills, this. From the date of promotion of his junior.
Which junior?
Yes. Yes, Sinha.
What is his date of promotion?
29/4.
29/4.
Yes.
But he was not in service.
That time he has not.
So he cannot get from 29/4. That.
But we have given promotional. Since we have given promotional, my lord, on the 64, it has been mentioned in the table, my lord, where on pro forma basis, on 2624, on 1G10/2006 on pro forma basis, 4750 or 110/2007 on pro forma basis, and 4750/29/2008 on actual basis. My lord, kindly consider, my lord, he is suffering one punishment of
stoppage of increment. Until which date? One increment. Until which date? There is no date, non-cumulative. There is a date, sir. No. That punishment ceases to have effect the date he is reinstated with, along with his regularization of period. After this order reinstating him, there is no effect of that punishment. That withholding of my lord's mouth, but my little understanding is, I yes. Wrong, my lord, and kindly allow me. He did not join. His punishment of one increment stoppage is non-cumulative. It means when he will next term of increment when he will get, that one increment has to be stopped. Since 1990, when this order was passed for stoppage of non-increment, he did not join. My lord, what is the date of that punishment order? Punishment order, my lord. My lord, it is 16 till 19. Second August 2004. Para 3 of the reply of page 45. Have you got the date? Yes, my lord. Let me see. What is the date? My lord, I'm trying to. It's 70 of the petition. Para 3 of the petition. 70. Must be in his representation. He must have given. Yes, I'm saying it. It is 70, my lord. My lord, it is 20th October 2000. My lord, it is in page 70, my lord. 70. 70, 70, my the record of the tribunal. Yes. My lord, it is third paragraph, I believe. No. It is in the third paragraph. October 2010, 2005. This was passed for that 1 month period of absence. Yes, or not. 11 when the punishment he has suffered, he did not appear on 11/10/99 to 16/11/19 for 1 month. Correctly, my lord says, and that is why, my lord, that 1 month, one increment was. Even then, he did not join. Then proceedings initiated and was charge sheeted, and then another order was. So this punishment of stoppage of one increment, yes, was it ever assailed by him? He did not deny, he never challenged that at any stage. My humble submission is, when a person is suffering from punishment and his junior elevated and he has got several increments during his absence, how can his payment, his salary can be stepped up and at par? There is no judgment as such, my lord. He is telling some judgment, Supreme Court judgment. I will request my learned friend to show that even suffering after suffering punishment, he can get the same benefit. Yes. This I believe my little effort to set. So this 2010, 2020 punishment will have its effect for how long? When he has joined, when he is supposed to get another increment. So therefore, we are for one increment. Yes. Now come to page 64. Yes. He has joined on 2010-2005. Yes. So next year he is entitled an increment. As per you, since that punishment has not been challenged, next year he is not entitled to one increment. So that will be 1/10/2006. Come to page 64, please.
Yes, my lord. Yes, my lord. Yes, my.
1/10/2006.
Yes.
That is the year in which he is to be denied the one increment.
Yes, he has joined, my lord. Kindly take. He has joined, my lord. Much later, no, when he has joined.
Please come to page 64. Please try to see what we are saying.
Yes, 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 yes.
You come to page 64. He has joined on 20th October 2005.
Yes, my lord.
So his one increment which was due in 2006, you say that he will not get.
He's not supposed to get.
That is what we are saying. As per your case is that punishment is not challenged, he will not get his increment in 6. So have you given him the increment in 7? See page 64.
Thereafter, he has elevated. He has elevated.
He has not. He has been elevated in 2008. Yes.
But his notional benefit for.
We are not on that.
Yes.
In 2006,
Yes.
a punishment withholding of increment for 1 year, can it be applied for 2 years?
No, my lord.
Then why you have not given him increment in 2007? On pro forma basis.
Yes, 2007, my lord. When he was getting 3350. And his payment in 2007, my lord, October, it is 4750.
Acha, the second column is the salary one.
Yes.
All right.
Yes. And my lord, 125 rupees increment per year.
That is
Not as per the scheme, my lord.
125.
That is why, my lord. But when he has assumed charge, he has joined assumed charge, then he is getting his increment. And again, 2009, 29 to 2000, he's from that day he is getting his salary with all increment. That is not his grievance that he is not getting any increment from that. Yeah.
That is not his grievance. Then that is why we are saying after he joined in October 2005, he should be getting the same salary as the junior with whom you have found him equivalent. You have found him equivalent. In
Not
fact,
the same grade, my lord. Not in the, he has not joined in the same grade. He has joined his earlier grade and thereafter he has elevated. Since his junior was elevated earlier.
junior has also been elevated from the same grade.
Yes, my lord.
It is not that he has come from a top.
This is why, my lord, kindly appreciate when his junior was elevated. Before that, he has got some increment also because he is not there. He is not supposed to.
No, he is also getting increment as per 64. He has got the increments. You see,
that is national increment.
You have given him the increment.
Next grade, my lord.
You have given him the increments.
My lord, 46
from 1500 to 1625, 4500 to 4625, then 4750, then
that is my lord. That is 4625, and thereafter, my lord, plus 125.
Yes.
Then 4750.
Yes.
Yes, God.
And before that also you have given him after his joining. 26/10/5 he has joined. In October 2006 you have given him one increment. From 45 it has become 46/25. Yes. And in the next year another increment of 125 has been added.
Yes.
Making it 4750.
Yes.
So everything you are giving him. But when you are giving him a promotion with in comparison to this Sinha, Mr. Sinha,
yes,
then you are only giving him the date and nothing else.
Now, for this seniority, my lord.
Yes.
He not to lose his seniority, we have given notionally. But he is not in.
Where is the order? This is the order.
And my lord, kindly consider, if he is remain absent, leave without pay, my lord, during that period, he cannot ask for the income.
He is not asking for that period. We are asking you from 26/10/2005. We are not asking for the period of absence.
No, my lord, you are true, my lord. Correct.
Therefore, we are saying from 26/10/2005. From then, how you can deprive him? Prior to that, we are not sure about what he is claiming. Prior to that, he may not be in a position as per our prima facie view. But once you have reinstated him, then from that date, how can he be deprived? Why he should get notional? Why he should not get actual? Prior to 26/10/2005, was not in service, he was not reinstated. It has been directed to be regularized with available leave, all that we can understand. After that, there is no penalty against him.
My lord,
After 26/10.
so take 1 minute more. That is, my lord, from 2010, when he was joined, my lord, his salary was 3350 in his Peter. Salary was 3350 amount in his lower grade.
Yes. Yes.
My lord, we have given pro forma basis since he did not assume the post. So 4500, his salary was
Equal to Mr. Sinha.
Thereafter, my lord, every year
You have added the increment also.
added increment
That is why we are saying you are doing everything. Why not giving the actual? What is the basis?
because, my lord, he was promoted and joined his duty from the higher grade. You will supposed to get the amount from that day. He did not serve in that category. How can he ask for the salary in that category?
Okay. Where have you said this in your reply? Let us see. In your reply filed before the tribunal, your written statement.
My lord, kindly come to my lord at page 69 onwards.
Yes, actual from his shouldering of the higher responsibility. That you have said.
Don't mislead my lord, this court, my lord. What I have no intention to mislead.
So this is the only dispute from 2005 till issuance of the promotion order. They say you have not worked, therefore he will not get. Actually, he will get from the date he works. You will say that you did not work because they did not pass the order. They have passed the order belatedly, so therefore you cannot suffer. This is it.
Supreme Court said, my lord, that in that
Let
case,
us see. You have repeatedly been saying Supreme Court has said,
my
but
lord,
you are not showing what the Supreme Court has said.
well, I have given the my lord, judgment, that is first judgment, my lord, that is not in this quantity, my lord, versus Candidacy Union of India versus T. Jagadish, that is I have given. My lord, I have given the all benefit by the department, not my lord, except my salary at par with my junior. That is my lord. My losses got it, my lord.
Yes.
Union of P. Jagadish, para 7, my lord, losses can 6 and 7.
No.
7, my lord.
Jagadish.
2 copies is there.
Just wait.
This is principle of stepping para 7. Person not getting it. Then leave it, my lord. I'll
No,
show
it is
another
here.
judge.
It is here.
Para 7. So far as the second question is concerned, this depends upon the applicability of the principle of stepping up. Admittedly, the respondents had been promoted earlier to the category of head clerk, and some of their juniors have been continued as a senior clerks against the identified post, carrying special pay of 35 and have promoted head clerk. Later than this respondent got their pay speaks at a higher level than the respondent, under the provision of the fundamental law, to remove the anomaly of the government servant promoted or appointed to a higher post, earlier drawing a lower rate of the pay in the post, then another government servant junior to him is this lower grade, promoted or appointed subsequently to the higher post. The principle of stepping up of the pay is applied. In such cases, the pay of senior officer in the higher post in required to be stepped up to a figure equal to the pay of fixed for the junior officer in the higher post. The stepping up is the required to be done with effect from the date of promotion or appointed to the junior officer. On the refixation of the pay of the senior officer by applying the principle of the stepping up, the new next increment of the said officer would be the drawn completion of the requisite qualifying service with effect from the date of the pay fixation of pay. The principle of becomes applicable when the junior officer and the senior officer belong to the same category and the post which they have been promoted in the promoted cadre, the junior officer being promoted later, it is the officer, then the senior officer gets the higher pay, being the principle of stepping up for containing the fundamental rules.
Yes, below that you are not reading.
Yes, I'm reading. I am reading. Stop already. Being the principle of stepping up contained in fundamental rules, and the admittedly respondents senior, being senior to the several other senior clerks, and the respondents having been promoted earlier, the many of their juniors who were promoted later, and the post of head clerk, the principle of stepping up should be made applicable to the respondent with effect from the date of juniors is as well cadre, and the senior clerks gets promoted to the cadre head clerk, and the pay was fixed at a higher club than that of the respondent. The stepping up should be done in such a way that the anomaly of the juniors getting higher pay salary than the seniors in the promoted category of the head clerk would be removed. The pay of the seniors like respondents would be stepped up the figure actual to the pay of fixed by India juniors visa in the higher post as head clerk. So I'm not.
This principle of stepping up, please read from there. This principle of stepping up, which we have upheld, would prevent violation of equal pay for equal work, but grant of consequential benefits of the difference of salary would not be correct. It is stepping up to maintain the parity, not grant of the difference of salary. But by reason of promotion, the promotee junior who worked on the said post in fact performed the work, whereas you did not, exactly what he is saying. And therefore, in the last also it says, stepping up of pay scale would be prospective to calculate future increments on the scale in the promotional post only prospectively.
calculate future increments of the scale, promotion post only restricted prospect. The appeal is dismissed, but in
So
second.
stepping up to give parity, but benefits, consequential benefits from the date of the duties being performed, not prior date. This is the judgment you have.
1997 judgment. I'm now losses can come to this judgment. One thing, my friend said, I lost one increment, non-cumulative. Non-cumulative, from next year I'll get that increment. That is the Supreme Court judgment also.
There is no effect of that.
That is my sequence. That is over.
That,
junior
there is
stage,
no effect of that punishment on you.
losses can come to that bundle.
Which other judgment?
Judgment first, Guru Charan Ragwal and another versus Punjab State Electricity Board. Losses can come to para 17.
17.
Plus we can also go to the para 14, 15, 16, 17. Also, something may be said regard to the Chabra's submission about the difference in increments in the scale of his applicant number 1 and C sorry at are placed. But the same is still contrary to the settled principle of the law that a senior cannot be paid a lesser salary than his junior. In such circumstances, even if there was a difference in the incremental benefits in the scale given to the appellant 1 and the scale given to the Mrs. Sori, the anomaly should not have been allowed to continue and ought to have been rectified so that the pay of the appellant number 1 was also stepped up to the Sori as appears to have been done in appellant number 2. We are unable to accept the reasoning of the High Court in the regard to or the submission made support of the Chabra, since the very object of the achieved being pay scale of appellant 1 on the par of his junior. So we clearly opinion that the reasoning of the High Court was erroneous and appellant number was also entitled to same benefit of pay parity with theory as granted in appellant number 2. We accordingly allow the appeals and set aside the judgment. So, this is even I'm getting less pay in the junior stage.
We are only on whether it is to be granted for the period.
When I was not in service.
Yes.
That
is not dealt with in this.
That is not 3
2009 3 SEC does not deal with this aspect.
That is
1997 3 deals with the aspect. It says it is to be given from the date the duties are being discharged prospectively. Which judgment out of this bunch shows or substantiates your claim for grant of actual benefits with effect from 2010? What is the date you have joined? 2010 2005. Just show us that is on
2005.
Just show any judgment on that.
On another there's a process can come to para 13 of the judgment, that is Union of India versus Onil Kumar. Next one.
Union of India versus
Onil Kumar. Circuit is really Malad.
Which paragraph?
Which paragraph lawsuits can come to para 13 at page 6. And kindly come to page 6, para 17. The conclusion of the number 1 should be read with mean that the promotion, etc., cannot be withheld merely because some disciplinary criminal proceedings are pending against the employee. To deny the said benefit, there must be relevant time pending at the stage when the charge sheet has already been issued to the. And that is after he was.
Yes, that they are referring to KV Janki Raman.
Yes, Malad, KV Janki Raman.
In contemplation of proceeding, they were denied the promotion.
Yes.
Then the Supreme Court held that until the charge memo is issued, There is no
Matlab.
proceeding, they could not have.
Matlab one, matlab Ramesh Kumar versus Union of India, it is a army personnel. Army personnel, matlab losses can come to para 11, 12, 13, 14, 15, 16. He was punished. He was jailed. Court martial, matlab jail. And thereafter, when promotion was well, the order that you have to give all benefits. Even it is found that he was promoted during the raid in army personnel.
Not this. Okay. Paragraph 14.
Paragraph 14, 11, 12, 13, 14.
14 to 16.
Hmm.
Ramesh Kumar
In
case.
normal circumstances, when the recruitment and promotions are affected,
Where the employee has been deprived of his opportunity to work on the higher post, he cannot be.
who has been punished, he has been jailed matlab in army. Even then, he was given all benefits.
We are observing in your favor.
Grateful matlab. And then I have a next matlab the Janki Raman's case. Janki Raman's case matlab I have annexed, that is 4.
Janki Raman, it. All right, you can read.
Even if I have been punished, even if I have been promoted, you have to give with the date of my promotion. And last said, since on that day I am not in service, so I lost my 3 days. And pay protection.
No, prior to your joining in October 2005,
I will not get
you will have a
losses due. I am bound down to it. Then
this is the
from the
prima facie
date of
view.
joining,
That is the prima facie view, because taking a lenient approach, humanitarian approach, the authorities have allowed you to join.
So if you also think that paid I cannot get, that is my.
That is our tentative. That is our tentative view. We are only saying what we are to solicit your submissions.
And my lot of one thing, Janki Raman said, no, so I'm not reading it. So last one I saw my lot.
Which paragraph from Janki Raman, please?
Janki Raman, my lot. Para 25, 26. Para 25, 26.
Show all the judgments that you have got. 25, 26.
25, Malab, we are not much impressed by the contentions at Malab.
Yes, please proceed.
Contentions advance on behalf of the authorities. The normal rule of the no work, no pay is not applicable to the cases such as the present one, where the employees, although he is willing to work, is kept away from the work of the authorities for no fault of his. This is not a case where the employee remains away from work for his own reasons. Although the work is offered to him, it is not these reasons that effect 17 will not be applicable. We are therefore broadly in agreement with the findings of the tribunal that when the employee is completely exonerated, meaning thereby that he is not found blameworthy in the least and is not visited with the penalty even on censure, he has to give him the benefit of the salary of the higher post along with his other benefits from the date of which he would have been normally been promoted, but for the disciplinary criminal proceedings. However, there is no matter here. Well, therefore, we are.
Yes, we can recollect.
And another judge.
FR 17 will not be applicable. That is what the apex court has said. Otherwise, employee is entitled to the pay and other emoluments attached to a post from the date on which assumes the office in terms of FR 17 of the CCS of the central government. But the apex court in this case has said that that FR will not apply where the authorities themselves have prevented for unjustifiable reasons.
On 20th October 2005. I have joined. So from that date, I have shown another judgment where my Justice Tapabutu Chakraborty was advocate.
Yes.
So how he got it? Justice Tapabutu Chakraborty was advocate. He argued the matter.
Yes.
It was appearing before his lordship.
Yes.
Why you are saying? Well, your lordship is there.
Oh,
But that time I was full. Now, my respectful submission, my lord, I am paying, my lord, from the lordship of hold that since I
now after there is a very narrow compass, whether he will get or not, that is all.
stepping at par with my junior. When I was promoted,
When did you claim the promotion? When did you make your first claim for the promotion?
my lord, I made
Seeking parity or stepping up?
lord, after joining, I made it.
They must not, wisdom must not have dawned upon them just like this. You must have
No,
made a claim.
They have already given me that benefit.
No, when did you
They
claim?
accepted it.
When did you claim priority with Mr. Sinha? When did you claim the
And a
benefit?
representation at page 55, 56. 55, 56. 29 June 2006.
55, 56.
Promotion to the post of clerk grade 1 with effect from the 1st November 2003.
29/6/2006.
28
That is
August
it.
2006. 28 August 2000.
Hmm?
28 August 2006.
No. Page 31, 29/6/2006.
31, page 55.
Page
Promotion to the
55,
post of
sorry,
clerk grade
50.
1. Yes. Page 55.
29/6/2006.
29/6 2006.
Any application before that?
No, Mala, that is not. And thereafter, on 28 August 2006. I understand your lordship's view.
January 2006. Earlier representation is of January 2006.
January 2006.
It is referred in page 55 itself, just below the subject.
Yes. Yes. In the circumstances, pray before your honor to promote me to clerk grade 1, putting the seniority position in the SK Sinha.
No, just below the subject. Refer my representation dated 25 January 2006. But that is not on record.
Oh.
That is not on record.
That is my promotion from the, because my junior saw promoted at the time. Dimension. Anyway, my lord, the authority accepted my promotion from 2005. That is my, if your lordship feels that from the date of my joining, plus 20th August 2005, that is, and stepping up at par with my joining. From the date of
Prior to your application, we are having.
My lord, my respect to submission, I understand process counting from 2000.
No, because we have to strike a balance. See, the Supreme
lord,
Court is
but-
on both aspects. There is a judgment. One, he is also correct that FR 17, the whole purport of FR 17 is what he is saying. That only from the date of assuming charge.
My appeal. That is for
You
promotion.
were out of service. You came back in service. You also forgot that you had to get a promotion. They also forgot. When you remembered, you made a claim. Thereafter, when they have delayed, that of course.
Deb, Pramana.
1 minute. We have allowed But we said that, my lord, in that letter, page 58, my lord, we said when post will be available. There will be vacant. The post has to be vacant, my lord. That automatically there is no vacancy. Page 58.
Type copy at page 59. Type copy at page 59.
There was so we said definitely.
No, but you could have stepped up his pay at least. You could have stepped up his pay at least. The stepping up of pay could have been done.
At Parishtuda, at Parishtuda.
His pay could have been fixed to maintain the parity.
Yeah. With that, my lord.
But you have done it in 2000, page 64 in 2008.
But from that day, my lord, now before that also.
No, not before that.
I have shown you, my lord, document, my lord.
In 2008, you have done it with effect from the date of his joining.
We have effect from the date of pay parity on the date when his junior elevated.
No, from the date of his joining. Not from the date of his junior.
And
That is the same. There's nothing new you are saying. That you have already said. Yes.
but our intention is not to deprive. There is not a single judgment that any person suffering punishment subsequently allowed to join my court. If thereafter elevated also, his seniority is not partly seniority again, but for equivalent benefit. Select is to get when he assumed the charge.
Class 17 would not apply.
And he cannot argue the documents filed by the railway.
Huh?
Against the document filed by the railway. That is, he cannot go.
Written notes of submission, my lord. It is with the.
You have elaborately said everything. We don't require any notes. You have any judgment?
Yes, my lord. In the written note, that is what.
Which judgment?
Judgment is, my lord. I have started. It is, my lord, Union of India versus our domination.
Yes.
Page 101 onwards.
Submission.
That
101.
Yeah.
So when this post was made available on which he has been promoted?
29th February.
Is that that fact is there anywhere? When this post has become available on which he has been promoted?
It's 64 months.
No, that doesn't show the date on which the post became available. That doesn't say that on becoming available. There is no indication of post having been.
There is no.
In your reply, in your written statement, have you said when the post became available? We are asking you.
Not the question or the not.
No. You have referred to page 58. Therefore, we are asking you. You said there was no post available.
Yes.
So that means when it became available, you gave it to him. So where is that date?
64 minor according to my understanding.
That does not say anything about post becoming available.
No.
In
This case also not that post was available by us. For this case as well.
No, but just because you write a letter that no post is available, that does not become sacrosanct. So we are trying to see when the post has become available, or it was a letter just like that.
What is case, my lord? Not
You have to satisfy us. We want to see.
Of course, my lord, correct.
Yes.
But since there are
Where is your written statement?
written statement, my lord, at page 70 onwards. page 69 onwards.
Yes, they have already stepped up. They have not been from this step. They have stepped up. Bit of that can be. Therefore, let us see.
And losses can say page 71 C, C and D. They said, since you are not in service, as such you are not given. No date has been set, madam. And rather they said that since I was not in service that time, so I was not promoted. And may I submit about the judgment he has referred?
Just.
My lord.
Yes, support punishment. Yes.
Well, the judgment shown by learned friend, man.
Half a minute, my lord, he has asked for, correctly, my lord, told, he has asked for promotion. We said, we will get promotion as and when post will. He never raised at any forum, before any forum, that there is a post vacant, but I have not got it.
That you have said, just now you have said. You have already said that. We heard you.
That's my lord, last 2 lines, my lord, my lord, out of my exuberance, my lord.
No, we have heard you. You said that.
Kindly excuse me, then.
Therefore, we asked you that you have raised the issue of post. It is not that he doesn't know. He says, why am I not getting? My junior has got. You said post is not available. One fine morning, you wake up and say, today we granted to you, but in this way. You don't say that now post is available. You are the one who say post is not available, but then you don't say that post is available. Where is he in the picture?
He is in the office, my lord.
We don't know.
Aware that there is a post vacant.
All right,
But
that
he
will
not-
that will consider. You have already said yes. Yes.
A judgment he has referred, it is not one thing, my lord, it is not reported judgment. Second thing, my lord,
But he has
in
given
this
you a
judgment,
copy. He has
KP
given you a copy.
Janaki
Why do you-
Raman's judgment not considered. And my lord, promotion is officiating promotion. Case of officiating
I have
promotion, not
not
the
seen
regular
the
promotion.
judgment yet. Let me see the judgment on.
Officiating promotion, last para, officiating promotion.
I'm reading. Where is
What judgment?
written
It is
submission?
officiating promotion, not regular promotion. This par inquiry, my responsibility is par inquiry. And lordship perusing his judgment, my lord. A last page, lordships can say, neither the senator nor the
Direct. Go to the last page.
say,
We are
officiating
reading.
promotion,
We'll read to the last.
not the regular promotion. Mention, not regular promotion. It is regular promotion.
Which one? It is covered by which of these?
And not a picture.
Give it from that.
Right,
6 years here.
Dipjyoti Chakravarti, huh?
Here he has not got the salary. That year he will not get it. He has suffered. Every case, moving the 2-3 implement. Get it from the big, the junior, maybe not the same amount. He was getting 100 rupees. 1,000 rupees. He missed 2 increments of 100 each. So he remained at 1,000. The other person, he went to 1,000. He got a promotion. He got a promotion. Now he is 135. He also got a promotion. 1,150. He is 1,150 from a better. He will not get the same pay, but he will get it from this pay. This shapes putting the office member. It gives the following instance. You know, this member. Small person. Starts from here. If 22 you have the FR, fundamental rules.
No one like it.
They have already done. Question they are not denying. They have done it. It's this is the fixation. See, in the lower, you will get 3,300. On promotion, they have given him 4,500. So this they have already, but they only fixed the paper. The money. So whether this material can be deprived from the which last paragraph you are showing us? Last
paragraph of judgment he referred, my lord. Last page I am going, my lord. From most of the grievances of the employees, that is, my lord, first paragraph of the last page 103. Most of the grievances of the employees will be met if proper means of the laid down in making local officiating promotion. On one thing, however, it clear, neither the seniority nor the regular promotion of these employees is affected by the officiating local life. So it is total officiating here. It is officiating. Our promotion is regular. And this is per income because other judgments are not, Janaki Raman's judgments are not considered.
Very well. The parties have been heard. Yes,
Monday,
dictate in court
judgment.
only. I don't want to
Monday for
dictate.
judgment, Monday.
Yes, I don't want to dictate right now. Monday will dictate.
Judgment given to judge.
No, for judgment.
Another my contempt matter, so I have to be.
You be here. It is only for judgment, no submission. I have said only for judgment. You can come late. No problem.
Junior ke particular.
Send someone. He will just be here. Send this. Yes.
Opportunity to place my all the cases irreverently by both the my lords. I'm grateful.
Yes.
Give us special sharing.
Valuable assistance. Valuable assistance. Valuable assistance.
Great.
Yes.
Grateful, my lord. Grateful.
Yes. Next.
Item number 14.
I'm praying for not today, my lord.
All right. Not
15.
I take care on behalf of the petitioner.
somebody is here. You have taken a resolution today. Should we proceed or should we?
Whatever. I do not want any order in their absence.
Not today.
Item number 16. Item number 17. Item number 18. 19.
Yes.
My lord, 19, my lord, in this matter, my lord, learned advocate Udayanaran Betal is appearing for the petitioner. My lord, due to his personal difficulties, my lord, he has not come to the court, my lord. Praying for not
today, yes.
My lord, one indulgence, if I may pray so. My lord, the matter may be taken up on Wednesday. I have a difficulty on Monday and Tuesday.
Ask someone to be here, not today.
Very good. Give you.
20, 21, 22.
22, I appear for the response. What happened? Can we order dated 14th of May 2024, Union of India has filed the receipt. Being agreed by the part portion of the order, applicant of the original application also filed a writ petition, which is not agreed. Now kindly have a look.
You have also filed a writ petition. What is the number?
And for the applicant,
What is the number?
not now.
It is listed today.
And that
Is it listed today?
No.
Then it has to be taken together.
the order that was passed. Matter be posted by the police. I will take up this matter after use.
This is what serious.
One is appearing in the story.
ECT 20. Oh.
20, item number 20. 204 is listed.
That is what has been called, right? Get this file.
And 242 is not appearing.
No.
Action file. Order action. Order.
Already like there. Order is there. Get that file. Not today.
Definitely, I think that let this matter be taken up on Wednesday. So I will not be here at Calcutta on Monday. So this is my humble prayer.
Ask someone to be here. There is nobody present for the petitioner. How can we adjourn it? Not today. That matter will come.
23.
23 I'm for the petition. Yeah. And this is a writ petition which has been not filed. It's registered at WPA because we had initially approached the single bench. One of the honorable single judge was pleased to refer the matter to a division bench, taking up tribunal matters. And primarily, I'll tell your lordships that because the tribunal has said that I cannot adjudicate because the judicial member is not there. The main issue is for regularization and for equal pay for equal work. We are all ex-servicemen who have been re-employed by the Kolkata police. And I'm led by Mr.
Orderটা কোথায়?
No, where is the file? Where is the file?
এখন দেওয়া হয়েছে?
We are sitting here and you are not handing the file. What is this? We have to wait for you. Yes.
Now let there is no bench available in the tribunal, milad. So milad, we having no alternative remedy, milad. We have come before Lordship, milad. I must say, milad, that before approaching milad tribunal, milad, we had initially approached the single judge.
No, he was just now saying that the tribunal has said that we cannot pass an order. Where is
Yes.
that order?
That order was handed over last occasion, but it is not part of that petition, milad. Milad, this is that order, milad.
No, this is not your case. You are Ashim Kumar Adhikari. This is somebody else.
No, Milad, there are a bunch of petitioners, Milad.
Show the order passed in your case.
Milad,
You said that
this is the petition only, Milad, in which, Milad, I am a party.
we can't make out from
Milad,
that order.
Now, kindly see, Milad, the application.
We cannot make out from that order, sir.
Milad, I can demonstrate from the petition that I have annexed.
Yes.
What number I mean? Milad, page 103 of the writ petition, Milad. What number? The serial number 4 is the writ petition, Milad. And Milad, the starts from page 102. This is the first name in the original application. And this is way 365.
What has he said? Read the order. Read the order.
This matter is taken up by the learned single judge pursuant to the order contained in notification number so and so, issued in exercise of power conferred under subsection 5(6) of the Administrative Tribunal Act. Submission, Mr. Banerjee, and counsel for the state respondent is that in this matter where the primary grievance is related to equal pay for equal work, and since the examination of such prayer involves various points of law, it would be appropriate if the matter is placed before a bench comprising of 2 members, judicial and administrative. Mr. Maithil and counsel for the applicant agrees to the views. In view of the submission, let the matter be placed before the bench comprising 2 judges. And in fact, Milad, there is only 1 administrative member available in the tribunal, Milad. And in terms of law, Milad, administrative member cannot hear out the matter, Milad.
That is not the subject matter of the present writ petition. The present writ petition, you are saying you are deprived of alternative efficacious remedy. You said that it has declined to hear. It has not declined to hear. It has kept the matter pending. It has directed to be listed before the bench of 2 members.
Yes, and there is no available, 2 members is not available in the tribunal.
It will come.
Since last 2 years.
Anyway, there's no, your counterpart is not here. What can be done today?
Monday?
Not today only.
বইগুলো নিয়ে আসতে হবে ট্রাইব্যুনাল একটা
Morning. Morning. There is one matter, I think, from the original side in the morning. After that. Give this file 13, serial 13, file set. Serial 13.